Thank you. Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama. Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller. Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orntlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. Please mark Assemblywoman Kasama absent excused. Please mark Assemblywoman Bilbray Axelrod absent excused as well. I think she'll be joining us hopefully in a little bit, but for now we'll mark her absent excused. That means we do have a quorum this morning. Good morning to members of the committee, those joining us on the Zoom, and good morning to members of the public who may be watching on the legislature's website or on the YouTube channel. Welcome to day 46 of the 81st session of the Nevada Legislature. Before we get started on this morning's agenda, I have just a few housekeeping matters to go over. If you're on the Zoom with us, please mute unless you are speaking. That'll help with the audio feedback. And for presenters today, if you could remember to state your name each time you speak, particularly after you are asked a question, that will help our committee secretaries prepare accurate minutes. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly okay. That's part of the legislative process. But we need to make sure we're being respectful of one another, of the legislative institution, and most importantly, our very hardworking staff. Finally, many committee members will be using multiple devices to access the meeting. This includes laptops, desktops, iPhones, iPads, pagers, cell phones, flip phones. You name it, we probably have it. So please don't see it as a sign of disrespect or inattention if folks appear to be looking away during the meeting. Most likely they're just accessing exhibits or helping prepare themselves for the meeting. So with those matters behind us, we'll move on to our agenda this morning. Committee members, members of the public, you can see we have two bills on the agenda today. We are going to take those bills in order as they appear on the agenda. At this time, I'll open the hearing on Assembly Bill 116. Assembly Bill 116 revises provisions relating to traffic offenses, and we'll welcome to the virtual presentation table Vice Chair Wynn, who's going to present Assembly Bill 116, and then we'll have some time for questions. So welcome, Vice Chair Wynn, and please proceed.
Thank you. Good morning, Chair Yeager and committee members. For the record, I am Assemblywoman Rochelle Wynn. I represent Assembly District 10. Today, I will be presenting with several individuals who kind of inspired me to take on this challenge. My primary co-presenter is Alex Wong. He's a high school student and resident of Assembly District 34. And as of last month, he's a newly registered voter here in Nevada. He was one of the primary people that participated in some of my earlier discussions of this bill during the interim, and he will be presenting some excerpts from a policy research paper prepared by UNLV law student Dane Smith, another student who's helped me immensely through this process. I also have Lisa Mosley back with us. She just can't get enough of us, and you know she loves this committee, and she's great to punt to when I can't answer all the questions. And I also have John Jones and Jenny Noble with the District Attorneys Association, as well as John Puro and Kendra Birchie with the Public Defenders to also answer any questions. Again, it is my privilege to be able to present Assembly Bill 116 for your consideration. As you heard, this bill seeks to change our current system for minor traffic and other related violations from being criminal in nature to being civil in nature. And with this, I will actually turn over some of the background information to my co-presenter, Alex Wong. And so, Alex, you can just unmute yourself and introduce yourself. Make sure you state your name for the record, and then you can begin.
Good morning, Chair Yeager and committee members. For the record, I'm Alex Wong, a resident of Assembly District 34, and I currently serve as a Nevada Youth Legislator and the United States Senate Youth Program Delegate of Nevada. I've had the privilege to work with Assemblywoman Nguyen regarding AB 116, and I'm honored to co-present this bill with her. The following is an excerpt from a policy paper by UNLV Boyd School of Law student Dane Smith. In the state of Nevada, all traffic violations are classified as misdemeanors. People convicted of misdemeanors are subject to up to 6 months in prison or up to a $1,000 fine or both under Nevada law. This detail might appear inconsequential, yet it is at the core of Nevada's current traffic adjudication system. Under this system, if you are ticketed for violating any traffic offense, you are being charged with a criminal offense. Although some may value the traditions surrounding current Nevada's traffic laws, custom alone cannot shield this system from its practical issues and systematic unfairness. Nevada traffic laws will affect everyone at some point in their lives. However, a person's socioeconomic background often dictates how one will fare in the current system. Many ordinary people who do not live paycheck to paycheck can just pay the fine and forget it. In contrast, indigent people face serious hardship when they are issued a citation that they cannot reasonably pay. At some point during their case, indigent people may choose to not appear in court because they fear incarceration due to delinquency. It is a reality many Nevadans face. A simple $400 traffic ticket can have a serious adverse effect on a person's life. Courts, in an effort to enforce the offense, may issue criminal warrants for these people. Many times this provides a tragic introduction to the criminal justice system. People who are incarcerated even for a day or two can lose their jobs, housing, or even have their child taken away by CPS. In addition to indigency, racial minorities are subject to more frequent contact with police and thus cited more traffic tickets. This creates a troubling disproportionality between racial communities and the amount of traffic tickets issued. Many tourists are also negatively impacted by the system. Visitors travel to Nevada to escape their everyday lives and enjoy the unique amenities of this great state. These individuals are usually unaware of Nevada traffic laws when they are pulled over. If they are cited for a traffic offense and pay the fines with all deliberate speed, they are inadvertently pleading guilty to a misdemeanor. Nevada's traffic law classification is working against the interests of the average Nevadan, its economy, and is demonstrably inequitable. We are funding the courts through these traffic citations off the backs of people who are least likely to afford it. We can potentially harm a tourist's life if she were to receive a citation on our roadways and pay it blindly. The system is also intuitively troubling. Because traffic violations are common and typically inconsequential, we as a society do not generally view minor traffic offenses as serious as other misdemeanors like shoplifting or simple battery. There is surely a better method to ensure Nevada roadways are safe and Nevada government is funded. At this time, I'd like to turn over the presentation back to Assemblywoman Nguyen. Thank you.
Well, now I've chose my co-presenter poorly because now I have to follow that. And well, I thank Alex for participating in this process. I know, I'm just truly inspired by like our young people in our state, their civic engagement. It's always inspiring. So I'm glad to be able to follow up him, and I'm humbled to be able to present this with him. Like you said, most states, including all of our neighboring states, have transitioned from a system that treats minor traffic infractions as civil offenses rather than criminal. Under our current statute and our current structure, if you are going 5 over, that is a misdemeanor, criminal misdemeanor. It carries with it a fine of up to $1,000 and up to 6 months in custody, as does beating your spouse. So that is also a misdemeanor, and it carries with it the same potential penalty and structure under our current statutes. All of these other states surrounding us that have transitioned from criminal to civil offenses have experienced not only reduced financial burden for those receiving citations, but also reduced the costs associated with criminal proceedings and detention, as well as a decreased burden on our court dockets. Nevada is one of the few remaining states clinging to this outdated model where all traffic violations are processed as criminal offenses. This measure has been a long time coming in our state. In fact, there have been a number of bills proposing changes to this system that I can see as far back as 2013. A similar bill was brought with strong bipartisan support in 2015 by former Assemblywoman Michelle Fiore in Assembly Bill 281. In talking with our current speaker and primary co-sponsor, Jason Frierson, he also made attempts during the legislative session in this area. In 2017, we yet again did an interim study that was approved to examine the complexity of this subject. And I can tell you it is that's true, it is very complex. And additionally, our own chair took on the task with Assembly Bill 411 during the 2019 session. And for those of you that can see, this bill in its same form passed with bipartisan support out of this committee in 2019 and also onto the Assembly floor in 2019. It is my hope that we have learned from some of those lessons from that study, from the 2015 bill, from the 2019 session, to gain greater support for Assembly Bill 116 during this session. Rather than take you through nearly 100 pages of text section by section, I do want to take this time to address this bill from kind of a policy conversation. As many of you know, I have been working with a hugely diverse group of stakeholders over the past 6 months. I was looking at my notes just last night, and it looks like I've taken the time to record 37 meetings with various stakeholders, including meetings scheduled for this afternoon with court administrators from around the state. I've looked at the work that's been done by those in the past and the interim studies and reached out to people that perhaps were hesitant or reluctant in the past. And today I'm proud to have a more diverse group of individuals and organizations in support. And I think that's what's needed when you're taking on such like a monumental task that has been done in other places, but maybe we just need to engage different people and explain to people why this applies to all Nevadans. Assembly Bill 116, again, establishes civil penalties for certain traffic and related violations. A violation of provisions of certain existing traffic laws or ordinances would be now a civil infraction, not a criminal misdemeanor. And I think the big distinction that we want to make sure, I think it's clear in the statute, but I have been working with stakeholders to ensure that it is, that under the current AB 116, unless a criminal penalty is prescribed for the violation by a specific statute, it would not. But, just out of an abundance of caution, I am not talking about reckless driving. I am not talking about hit and runs. I am not talking about DUIs. I'm not talking about those type of misdemeanors. And so I have been working with various prosecutors, and in fact, we have Jennifer Noble as well as John Jones on the line to kind of talk about some of the conversations that we've had, because they are newly supportive of this bill as well during this session. And I think it's because of that broader conversation about how we can make implementation of this process and this policy more seamless than it has looked in the past. So we are definitely looking at carving out certain types of what I'm going to call serious criminals that probably would be and should be considered not a civil infraction for a minor traffic. Like I said, the main purpose of this bill is to make sure we are not arresting, we are not incarcerating, and we are not branding people as criminals for committing minor traffic violations, whether that's Nevadans in our own state or tourists that are coming here. Especially when these individuals may not have the resources. Today is Indigent Defense Day in our state. And so I think it's important to recognize, the work and how most of these traffic matters. And Ms. Mosley can talk about how this does disproportionately affect our indigent population. Again, it would affect a wide range of traffic behavior, including speeding, driving, illegal turns, driving without a seatbelt, or not complying with directives in a construction or school zone. Please keep in mind, again, more serious traffic matters will still remain criminal misdemeanors like reckless driving, DUI, vehicular manslaughter. So we're not transitioning all breaches of law to this civil infraction system. So I'm going to kind of highlight some of the sections that I think have been most concerning that people are bringing up, and also sections that we're actively working on to try to get some guidance in the area. I want to make it very clear. A lot of times people were like, well, how do we track whether or not we have people that are repeat bad drivers? Like, how do we make sure that they are still, this is still being monitored? We're still capturing that. And I want to make it very clear that sections 9, 11, and 12 make it clear that even though these are now civil infractions, they still count as infractions on a person's driving record. I believe we have Jenny Noble here and John Jones, mostly Miss Noble, to answer any questions about the traffic point system and some of those aspects of it. Moving on to section 23 and 26, this kind of will explain the procedure of how a case would be processed in a court under this civil procedure. And Ms. Mosley can also speak to this because we've looked a lot about how courts transition and how states transition and how they implement that. And a lot of times we still use the same judges, the same hearing masters, the same ticket people, the same clerks. They are just processing them under a more efficient system. So instead of having the protections under law for a criminal citation, for example, beyond a reasonable doubt, we have some other provisions that make it a lot easier to process these tickets. Section 24 provides notice of the civil infraction and what that would look like when it would be handed by a field officer. I know I've met with law enforcement and I will continue to do so. One of my main things is I want to make sure that they don't see any differences in the field when they're issuing citations, when they are making arrests. Just because this is a civil infraction, their job should not change. And in fact, under the current circumstance, instead of being subpoenaed to court for a criminal trial, they would now be able to potentially submit an affidavit in support because the standard would be so much lower to convict on a civil citation than a criminal conviction. I've had conversations, again, like I said, with law enforcement, and I will continue to work with them on that issue. Section 26 makes it clear that, and if there needs to be additional language, we are working on that too, that if a police officer is stopping someone for committing a civil infraction, for example, speeding, and then they pull up to the car and they realize the person reeks of alcohol and they are now going to have to arrest them for a DUI, that those civil infraction and criminal misdemeanor will now stay together for ease of investigation, for ease of prosecution, and they will stay together. So we are working on how that language will actually look in our statute to be able to enact that policy. Again, I could go through all the sections one by one. I know that this is a policy committee, but I will recognize that the fear and anxiety of the fiscal impact is continuously what seems to derail this in the past. Section 34 speaks to where and how the money is distributed. It currently suggests that this money exclusively be put in a permanent education fund. And under our current existing structure, that happens to a certain extent. I am looking and working with stakeholders to find creative ways to address how the funding will go. For example, Colonel Ann Carpenter with DPS Highway Patrol Division has made some suggestions about traffic and public safety education and some of those funds possibly being diverted to that. If the goal is to make our roadways safe, and that is what we are trying to accomplish, incarcerating people probably is less effective than educational programming that we might be able to use with this. Additionally, I know that many of the current funds that come from our traffic tickets fund a lot of our specialty court programs, which have also shown to have a significant fiscal savings for our municipalities and county courts. So I am aware of the current funding structure, and I don't want to disrupt that. And so while I may probably fundamentally disagree that we should be funding our courts and government on the backs of traffic citations, I also recognize and I'm inflexible enough to know that I need to be realistic. I need to be and come up with pragmatic solutions for our local government. And so some of the things that we've talked about, and I would love to hear our committee members' thoughts on some of these policy decisions in this area. And some of the things that we've talked about is temporarily using this money so it remains with local governments, so they can implement these new processes, so they can implement these new systems, so they can maintain their specialty courts, and they can kind of maintain the status quo, if not giving them additional funds to be able to transition into this new system. Again, this kind of concludes my presentation on Assembly Bill 116. For me, and hopefully for you all, it is evident that a small debt in fines and fees from the current traffic violation system can be compounded, can spiral out of control so quickly for so many Nevadans. And adopting this measure would alleviate any financial burdens for drivers, local governments, or other, people that result from the penalties related from these minor traffic violations. I do have Ms. Mosley. I know that she is prepared if you have questions kind of about the implementation and how this has looked in various states. Specifically, I think she's looked most recently at how this was implemented in 2000 or in Arizona and what they're doing there. Like I said, I know that Mr. Jones and Ms. Noble and Mr. Pirro are also available to answer any questions that you might have. So if you do have questions, I will probably punt them to those individuals to talk about what our solutions are. And with that, Chair, I'm ready to take some questions.
Thank you so much, Vice Chair Nguyen, and thank you, Mr. Wong, for helping out on this and providing your testimony. You did a fantastic job this morning. Before we take questions, I want to thank you for taking this issue on. Members of the Judiciary Committee who were here with us last session may be having deja vu on this issue. We did hear this bill in some form or fashion last session, and I certainly can attest to the fact that it's way more complicated than you would think at first blush to try to get this figured out. And it sounds like efforts are still ongoing. So thank you, Vice Chair, for taking this and bringing in a lot more people to this conversation. I learned very quickly last session that you need to have a room full of or a Zoom room full of 50 people to get this figured out. So it sounds like those efforts are ongoing, and just want to encourage you to keep doing that. Committee members, obviously we had a pretty high level presentation about what the bill seeks to do, and I think if we get to a work session on this bill, it'll probably look very different than Assembly Bill 116 that you have in front of you. But I wanted to give folks a chance to ask some questions. If it's on the bill in particular, great. If it's on sort of the concept or the philosophy behind where the bill's going, that is fine as well. So if committee members could just raise their hands and let me know if you have a question for Vice Chair Nguyen or the folks who are on the Zoom with her today. Unless we've tired everyone out from yesterday's hearings. We're going to start with Assemblyman O'Neill.
If it works. Thank you, Chair. Ms. Nguyen, just a quick question, because I thought I understood and now I'm a little confused. On the fines, the courts can still add their court assessments or fees on top of the original penalty for the infraction. Is that correct?
You know what? That is the section that I'm really looking at. Like I said, currently the way I have it included in Assembly Bill 116 is that it all goes to this permanent education fund. And while I think funding education is appropriate, I think under these circumstances, while we are transitioning, I would like to come up with a more pragmatic, realistic, fine collection. And like I said, I'm not opposed to temporarily allowing these city and county governments to keep all of the funds to a certain extent, but I would like to, because I know that they're using it for things like specialty courts, so that is something that I'm definitely open to making this transition easier. I don't want to make it a permanent thing because I think that we should be putting that money into the education fund. And so we are working with legal. I'm just waiting for them to finish up all of our other bills to be able to kind of put some of these concepts that we have to see what they look like in writing. I don't know if that really answers your question, but that's my intent.
It does. I appreciate it. Thank you. Thank you, Chair.
You're welcome. And, I'll note for the record too, just because I remember working on this, the way that the system works now, if it's a state fine, so not a county or local fine, but a state fine, it goes into what's called the state, I think it's called the permanent school fund. And that's an account with the state. And so that account just sits there and really is a trust fund. And then the interest that is generated on that account goes to fund schools. And I'm not going to pretend I know the mechanism by which it funds the schools, but so that's just a pot of money where state fines go. And over the years, there's just been, I guess, some concern about how fines are being levied and who's levying those fines, whether it's the state or local government, and where that money goes. So hopefully that's helpful for some context, but certainly makes sense that we might want to give locals some of that money to be able to implement something we're asking them to do. So hopefully that didn't bleed too much into testimony, but just wanted to help answer that question.
No, that's very helpful. And sorry, Rochelle Wynn for the record. One of the things that I learned through this process last session, in watching our own chair kind of go through the process and struggle with this super complex system of traffic citations, is that if the ticket is written under an NRS, the funds are supposed to be diverted into that. But a lot of our municipalities and counties have their own corresponding traffic ordinances. And so officers are writing tickets under those ordinances. And so they're not even going into the permanent education fund. They're going into the local governments. And so when I had indicated initially, I'll just have it go kind of where it goes now, transitioning into this new system, which would include, it's my intention to include county and city ordinances, and decriminalizing those as well, that inadvertently would take away a lot of the financial resources from those things. So that's why I've been open to diverting some of that, more of that funds directly back into the courts and the municipalities.
Let's go next to Assemblywoman Summers Armstrong, who has a question on the bill.
Good morning, and thank you, Chair Yeager. I'm sorry. Vice Chair Wynn, lovely presentation, and a very important issue right now as we are talking about all over the spectrum, looking at how we look at our criminal justice system, and I appreciate it. Does anyone that you brought with you today have any statistics, dollar amounts? I'm particularly interested in if anyone has data on municipal or county minor infraction tickets that are issued each year and what they are generating in income or fees, if you please, for those municipalities and government agencies. Thank you.
I don't know if I have any specific numbers, but I bet Ms. Mosley might have some general kind of conversations about what those numbers look like. Like I said, I am meeting with some court administrators later on today from some of the municipalities, and I could probably get that information to the committee so they have a better understanding. I know in working and watching Chair Yeager go through this last session, it was quite difficult to get that kind of information from most of the local governments to put a number on exactly how much money they are doing from that. But Ms. Mosley, do you have any answers to that?
Good morning, Elisa Mosley. As you have said, it has been a bit of a challenge to get that kind of data out of some of the jurisdictions. We have submitted records requests to almost every jurisdiction. We don't have a lot of the numbers as far as how much they are collecting. We do have some data on the number of warrants in some cases. For example, Las Vegas Justice Court last year had over 270,000 outstanding warrants just in Las Vegas Justice Court alone that as a result of COVID, they suspended. When we looked at Henderson had about 58,000 outstanding warrants. And just jurisdictions across the state had similar numbers. And so we do have some data as far as the number of warrants, and it's pretty dire. But as far as what jurisdictions are actually collecting from those warrants, what kind of revenue, we have not been able to collect that data yet.
Thank you, Chair. Thank you, Ms. Mosley. Chair, if I might just follow up.
Yes, please.
with another question. So, Vice Chair Nguyen, if we cannot parse out the dollar amount that these warrants and these tickets are generating, how then do we not move forward against the concerns of these courts and municipalities and deal with what we do know, which is that when people's licenses are suspended or they are arrested, that they are put in jail, that they lose custody of their children, as the young man read from the report, that people lose jobs because in this state, you don't show up for 2 or 3 days. If you don't have bail money, you're going to lose your job, your housing. So how do we balance the needs of the community and then the needs of the municipalities for income? It's really not confusing, but a little frustrating. And I just want to make sure that I'm clear on how this will affect everyone, so that the decision making is just easier for me to do. Thank you.
Rochelle Nguyen, for the record, that is a very real concern. I mean, obviously, we have had difficulty getting those numbers. I will say that in submitting this bill, if you go on to Nellis, you will start to see some of these fiscal notes being submitted from various jurisdictions about what the costs or what they are going to see potentially as disappear. I've seen some of those fiscal notes that say that there are certain jurisdictions that are collecting over $250,000 in ticket warrants. And so they are concerned that they will lose that. On the flip side, we have had ongoing conversations, and I will tell you that all of the municipalities and county governments that I have talked to so far are willing and recognize that we probably need to make this shift in policy, and it's how we implement that policy shift and how we pay for it, at least temporarily, because there are going to be added costs in doing that. But on the flip side, I've also asked them to try their best to quantify some of the other savings, fiscal savings. I think that's why I have a lot of broad support from Americans for Prosperity, and I saw NPRI on there supporting Assembly Bill 116 now. So I think some of these organizations that have are big on fiscal responsibility also recognize that there is a significant cost savings that these municipalities are not quantifying. In meeting with Carson City during the interim, they had kind of done a pseudo type of decriminalization. They weren't issuing warrants any longer. They weren't adding additional warrant fees or collection fees. And they were utilizing a collection agency, in collecting their traffic matters, because I think they saw some of the movement from 2013 to 2019, and they wanted to see how they could implement that. One of the things that really stood out to me, and I think Mr. Wong was also on that call, as well as some other individuals and Ms. Mosley, where they were able to try to quantify the other costs that they were now saving not arresting people on traffic warrants. So I think they calculated at $565, and that was the amount of time that the officer had to spend on stopping an individual on a traffic warrant, impounding their car, searching their car, doing an inventory, taking the individual down to the police station, booking them in. And then they were also able to quantify, or they tried to attempt to quantify, the amount of time that it took their clerks to enter in warrants when they were not issuing warrants for robberies. They were issuing thousands of warrants for traffic matters. So they were trying to quantify the number and the resources that went to that. And then they found on average, I think people spend 72 hours at a very, on an average in the jail. So quantifying that, I think now we're calculating at $170 a day, $150 a day, somewhere in there. Either way, they're all for 3 days in jail. And then not to mention so just on that aspect, how much money were you doing to collect that $150 speeding ticket warrant? How much money on the other end did you have to save? I know that I have John Jones here from the Clark County District Attorney's Office. I'm sure he would be able to answer questions about how the deputies in his office, they want to be able to prosecute real crimes. They want to get out of the courtroom and in the business of enforcing parking tickets, because their resources and their skill set and their knowledge could be used in a better mechanism. Everyone's hurting, and so this is the time to be able to consolidate your resources and use them more effectively and efficiently. Mr. Jones, do you have any comments to say on that as far as how that it impacts the district attorney's office?
We cannot hear you, Mr. Jones. It appears you are speaking and unmuted, but maybe your volume is down. And anyone else?
I thought it was the best lawyerly speech ever.
Mr. Jones, this is broadcast. If you were to toggle between, if you go to the lower left corner, you can toggle between your speakers or same as system. That may fix the issue. We still cannot hear you. If you have the select a speaker's headphones or same as system, toggle between those a few times. Unfortunately, we still cannot hear you.
I think the very capable Miss Noble might be able to give some information as well.
Good morning. Good morning, Mr. Chair and Madam Vice Chair and members of the committee. My name is Jennifer Noble. I'm here today on behalf of the Washoe County District Attorney's Office and the Nevada District Attorneys Association. We have in Washoe County, we have about 2,400 sites that come to our office a year. That's for 2020. And that doesn't include people who have citations that go before the judge and then just plead, guilty based on whatever offer the judge gives them. Most of these citation trials, I can tell you because I'm a very experienced traffic trial deputy, involve essentially me going in, or would involve me going in and saying, Officer so-and-so, calling your attention to this date and time, what happened that brings you to court? And then my questions would be, what happened next? What happened next? And then the defendant would tell their side of the story and the judge would make a call. So in these scenarios, it's not, at least in my view, for the bulk of traffic trials that I have done, the DA doesn't really serve an essential role. I'll also add that, for example, in Washoe County, our office services Sparks Justice Court, Reno Justice Court, Wadsworth Justice Court, and Incline Justice Court. And so deputies will spend, in Reno Justice Court, I believe it's 5 days a week, or pre-COVID it was. They're kind of trying to work around things with Zoom, but we do spend a substantial amount of time with deputies driving back and forth to courts in Wadsworth, in Incline, et cetera, for what I believe the majority of are fairly simple trials where the officer could perhaps just give his version of events and the defendant could give his version of theirs, or his or hers. But I'd also add, for example, in Elko County, the DA there shared with me that they are having deputies drive an hour and 40 minutes each way just to do traffic court. And so it is something that I think in times where we don't have enough resources to do everything we want to do, having traffic become civil in nature would assist DAs in being able to focus on criminal cases.
Thank you, Ms. Noble.
We'll go next to a question from Assemblyman Wheeler.
Hey, thank you, Mr. Chairman. I'd like to ask my question of Mr. Wong, if I could, Youth Legislator Wong. I've been heavily involved in the Youth Legislature in my first 4 sessions. And I'm sorry we haven't met, Mr. Wong. I haven't been so involved in it in this session. But I know you guys really do your homework when you're presenting a bill. I've seen you do it. So I wanted to see if you knew the answer to this question. Mr. Wong, Ms. Mosley said there were 58,000 outstanding warrants right now just in Henderson alone, which means probably well over 100,000, wild guess. throughout the state. And this bill takes effect on January 1st, 2023. So do you know, Mr. Wong, if this will be retroactive and everyone who receives a ticket now will have that moved to a civil infraction when it on January 1st, 2023?
I think he might still be there, Assemblyman Wheeler. I know that I had him step out of school, so I'm not sure if he is still on there. He is a high school senior. He is trying to finish up. I know he's waiting on college admissions, but I will tell you, even that date is flexible. And it, just so you know, it is my intent to make it retractive.
I kind of figured it was. I just wanted to see if he knew. I
know he knew. I know he knew it.
Okay, thank you.
He may be accessing multiple devices as well today to participate in school.
He had told me he's like I'm gonna have my class on another computer, so I know that he is the epitome of multitasking.
And if he didn't know the answer, the way he handled it was perfect.
There is something to be said for not being in the room to not get a question you can't field. That's for sure. Okay, moving along. We probably have time for maybe another question or two because we do have a lot of folks who are interested in testifying on this bill. I want to give committee members a chance if there are other questions out there. Just let me know. Okay, let me get everyone on one screen. So this is really interesting. I've got Mr. Jones, Ms. Noble, and Mr. Pirro all right next to each other at the virtual table, on my screen at least. So that doesn't happen often, which is nice. So I think, go ahead, we'll go to you, Assemblywoman Hanson, for a question.
Well, so, whoops, are we there? It's kind of a quasi question. Thank you, Chair, for the opportunity. And thank you, Vice Chair, for bringing this bill. I love this principle. I love the idea of decriminalizing this. It only makes sense. Back in 2019, I had discomfort with 411, even though I agreed with the principle. And I appreciate that you're trying to navigate, because here's where I am. I have 7 counties, and I know, I have 7 county commissions that got to deal with this, or 7 sheriffs. And so I know that you're trying to do this dance, and it sounds like there's like a restructure that has to take place with the fees or breaking out things. So I'm totally hoping this can come together, and wanted to, if you're talking about maybe a temporary, like if the bill were to get the right stakeholders on board, there would be kind of a temporary rollout. Is that what you were saying? So we could kind of figure out long-term how this is going to look?
I'm definitely open to that. I think Ms. Mosley might be able to speak to how it rolled out in Arizona or how they transitioned. Is that correct, Ms. Mosley?
Yes. What Arizona did, their justice courts and municipal courts both hear traffic cases, civil and minor misdemeanors. What they've done is they've created 2 classes of infractions, one being level 2 misdemeanors, anything that's not, and civil infractions, level 2 misdemeanors and civil infractions. The level 2 misdemeanors being the more, what we would consider the more serious ones that you spoke of earlier. Other ones being civil, things like expired registration, rolling stop or something like that. But the more serious ones that we talked about earlier, they've classified those as level 2 misdemeanor. Their justice court and their municipal courts hear those cases concurrently. They didn't change a lot of their software. They didn't have to change anything else. The same judges that were hearing those cases continue to hear them. As I said, they just created a level 2 system of misdemeanors for more serious offenses that are not civil and civil infractions, and they hear them the same way.
And that, thank you, or Rochelle Wynn for the record. Assemblywoman Hanson, I think that's been the biggest impediment. When I'm talking to some of the court staff, when I'm talking to judges, they're like, well, how do we do this? And I was like, well, we do have about 40 something other states to look at to see how they've done it, how they've implemented it, and they seem to be pretty successful. It's not like we're like #1 in traffic safety because we criminalize traffic. So I think we need to look at some of the things that do make our roadways safer. And it doesn't appear to be a correlation between making it a criminal citation as opposed to a civil infraction, because most people honestly don't know that it's it is a criminal like infraction. So that is what we were looking at. And talking to some court administrators, they're like, yeah, I think we could just seamlessly incorporate this. It might cost us a couple $1,000s to figure it out. And then I've had other jurisdictions that are like, it's going to cost me $40 million to come up with a new system. So I really do feel like there's some sort of happy medium. And so and it is difficult and other states have gone through this as well. How do you effectively, efficiently, and fiscally transition into this civil thing? And I think it's reminding people of the bigger picture as well.
Thank you for taking on this monumental task, and I'm on the sidelines cheering. I hope we can get there. So thank you so much.
Thank you, Assemblywoman Hanson. I think we probably ought to move to testimony on the bill. There are a number of people on the Zoom and in the queue. I'm not sure if they're here for this bill, the next bill, or both, but my intent is to, given that we have another bill with a lot of interest, is to take about 20 minutes or so of testimony in support. So I want to thank Vice Chair Nguyen, Youth Legislator Wong, and the others who were on the Zoom with us for helping to present. We'll ask you to sit tight while we take testimony in support. So at this time, I'll open it up for testimony in support of Assembly Bill 116. I think we have, if I'm not mistaken, I believe Ms. Noble, Mr. Pirro, and I don't know if we have Mr. Jones's audio back, but I think they probably would like to testify in support. So Mr. Pirro, why don't we go to you first for your comments?
Thank you, Mr. Chairman, for allowing me to speak, and thank you, Vice Chair Nguyen, for bringing this bill forward. John Pirro from the Clark County Public Defender's Office. There's a hidden cost to criminalizing traffic tickets. Mr. Wong in his testimony hit the nail on the head. If somebody gets arrested on a Thursday and they don't get out till Monday because they're arrested for a traffic warrant, CCDC costs all of us $190 a day. So that's $570 more than the ticket probably costs that we as taxpayers are going to front to imprison that person for not paying a traffic ticket. Moreover, traffic tickets are delaying people from getting treatment in specialty courts. Oftentimes, specialty courts can't start somebody on a course of treatment without first handling a municipal court warrant. So you have a person sitting in custody for up to a week, 7 days, just to handle this traffic warrant before they can go get their mental health treatment, before they can go get their drug treatment and be released and start working on their life and repairing the damage they've done to the community. And if we keep that person in there for a week in the Clark County Detention Center, that's $1,330 that we as taxpayers are paying. Now, I'm not Jeremy Aguero. I wish I was, because then we could work out all these numbers and figure out that really the counties and the cities aren't making their money by criminalizing these things, because we're paying for a lot of this in incarceration. So there's a big economic deep dive that we need to do that hasn't been done. But I think if we did it, we would see that we're really not making the profits that need to be made by criminalizing, because we're losing a lot of money by putting people in custody at the cost of a day in jail, where at a minimum, you're looking at $190 in the Clark County Detention Center. There are medical students that have to report these as crimes on their record because of the way Nevada does that, and that's hurting those students here, especially when UNLV has just started their medical school. So we're trying to get there, and Toro has been here and testified on this bill before. There's also a human cost, not just a taxpayer cost. I've handled bench warrant clinics where people were unable to pay their ticket. Then they get arrested on their warrant. They're in prison for the week, and they're already living paycheck to paycheck. So now they can't afford their rent anymore because they've lost their job. And a traffic bench warrant has basically ruined that person's life, and it's taken them a long time to get it back. I've also shown Chair Yeager and Vice Chair Nguyen traffic tickets from the municipalities for a simple traffic ticket that's skyrocketing costs up to $2,300. I don't know about all of you, but I personally would have trouble paying a traffic ticket at $2,300. And I'd be super frustrated about that cost. So I urge this committee to please pass this bill, and I thank you all for considering it.
Thank you, Mr. Pirro. Appreciate it. We'll go next to Ms. Noble.
Thank you, Mr. Chair. Jennifer Noble for the record. The Nevada District Attorneys Association is in support of this bill with the understanding that there will be some changes, as Madam Vice Chair Nguyen referenced. We certainly want to make sure that reckless driving, DUI, revoked due to DUI, perhaps, some of hit and run, some of the more serious offenses are not part of this bill. And I think that there's a general agreement on that. But for the vast majority of these tickets, I don't believe that prosecutorial involvement is necessary. I think that we can do this without changing things for officers in the field. And passage of this bill, in addition to the points that Mr. Pirro mentioned, would allow us to conserve some resources and not be traveling to a bunch of different courts just to ask people what happened next. I think that we're a little bit obsolete in a lot of these traffic trials. And so we'd urge your consideration of this bill.
Thank you for your testimony, Ms. Noble. Mr. Jones, let's see if we've got your audio working.
Can you hear me now, Mr. Chairman?
We can. Please go ahead.
Thank you. I apologize for the technical difficulties earlier. And I want to thank you, Mr. Chairman, and Vice Chairman Nguyen for bringing this bill. I know last session, Mr. Chairman, you championed this, and now Vice Chair Nguyen has taken it over. And this is my sixth session representing the elected DAs at the legislature. And over the course of every one of those sessions, we've had discussions about making traffic violations civil in nature. And I myself have been opposed or in the neutral position on this bill in the past because the language wasn't exactly right. But we are here in support this session, and we believe that the time is now. I don't want to come back 6 sessions from now still referencing this testimony. Because in all the discussions that we've had about criminal justice reform, it seems that we have ignored the most obvious candidate for reclassification in terms of bill passage, that being traffic. We're talking about low-level, minor traffic offenses like speeding, having your tail light out. It surprises most people to learn that they are committing a misdemeanor offense when they commit a traffic violation. Now, as Jenny indicated, there are offenses that we think should remain criminal, but a large number of these current misdemeanor crimes can be reduced to civil infractions with little to no impact on public safety. And some of the points that were already discussed by Jenny are giving prosecuting agencies the discretion to prosecute these cases based on their own individual agency resources and priorities. I want to point out that prosecutors in Maricopa County, Arizona, that's the Phoenix DA's office, they don't appear in civil traffic court. And judges, from small claims court to TPO hearings, judges regularly have to make decisions on about 2 interested parties without input from a prosecuting agency. So this really wouldn't be that new for them. And we have had conversations with Vice Chair Nguyen, the defense bar, and others about this bill, and we are close to getting this done. And I want to point out, and this kind of goes to Assemblywoman Summers Armstrong's question and Assemblywoman Hansen's question. We're not going to get this perfect this session. Nobody expects it to be perfect. I'm thinking of AB 236 last session to our new Cannabis Compliance Board. Every big bill that this legislature has passed has required changes over multiple legislative sessions to get it right. And we should be under no delusions that this bill will be no different. But to end on a famous legislative cliche, let's not make the perfect be the enemy of the good and pass AB 116. Thank you for your time.
Thank you for your testimony, Mr. Jones. Ms. Mosley, let's go to you for testimony and support, please.
Thank you, Lisa Mosley, for the record. I echo everything John just said. We know that this bill will bring relief to a lot of people who are experiencing getting warrants for not being able to pay minor traffic violations. And I'll tell you that since we've been in this hearing, I've actually gotten a call from a gentleman, I won't say his name, a gentleman, 70-something years old, who is still terrified that he is going to be arrested. He lives on Social Security. He got a ticket pre-COVID and was not able to pay it, and it is in warrant status. And he calls me at least every week to find out how we're doing and if there's any way that we can help him. And so I'm thinking of people like him. And I also want us to be mindful of not only what courts think that they're going to lose or how much money it's going to cost them to implement this. There's going to be savings to the state, not jailing people, making sure that law enforcement officers are not taking time out of their day to jail someone, tow their car, transport them to jail. Those things cost money. Those things cost a lot of money. And with non-court staff, with civilian staff, all of these things cost money. So I think the overall savings to the state is going to be much greater than what we expect. And as John said, let's not let perfect be the enemy of good. Let's get this bill passed and let's figure out a way to implement it. We got a lot of smart people in this committee, a lot of smart people in our legislature, and a lot of smart people in our courts. There's no reason why we should not be able to pass this bill and implement this in a way that's going to be effective for everybody. So I urge the committee members to pass this bill, and that's my support.
Thank you so much, Ms. Mosley. I appreciate your testimony. I don't believe we have anybody else on the Zoom in support, so I want to go to the phone lines, and we're going to get through as much testimony as we can in the time that we have. So I would encourage callers, if you're able to keep your comments brief or say me too to what has been said, that'll help us get through as much testimony as we can. BPS, let's go to the phone line and take the first caller in support, please.
Thank you, Chair. To testify in support of Assembly Bill 116, press star 9 now to take your place in the queue. And we'll begin our call with the caller with the last 3 digits of 080. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hi, Jim Hoffman, Nevada Attorneys for Criminal Justice. NACJ supports this bill on both a practical and a moral level. Previous speakers have given a lot of examples of why this is good on a practical level, but I want to talk about the moral level a bit more. We're not supposed to have debtor's prison in the United States. That's literally something out of a Charles Dickens novel. The idea that people should be locked up because they're too poor to pay is something that we as a society firmly reject. And yet, this accidental loophole is developed where people are taken away from their jobs, their homes, their children, and put in jail because they can't afford to pay traffic fees. That's not just practically wrong, it's morally wrong. NACJ supports AB 116 because that's a way of fixing that moral harm and making Nevada a better place. Thank you.
Thank you for your testimony, Mr. Hoffman. BPS, let's take the next caller, please.
All right. With the caller, with the last 3 digits of 725, caller with the last 3 digits of 725, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, and thank you, Chair Yeager and committee members. This is Nick Shepack, NICKSHEPACK, Policy and Program Associate with the ACLU of Nevada. I want to thank Assemblywoman Nguyen for bringing forward this important piece of legislation. I also want to thank Youth Legislator Wong for his amazing presentation. Few presenters are as clear, easy to understand, or as prepared as he was. The criminalization of traffic tickets is a major issue in this state, an issue that we can fix this session. It is a racial justice issue, with 2/3 of Las Vegas traffic warrants going to black and brown drivers. It is an economic justice issue. Those with the least money are at the highest risk of being unable to pay fines and most likely to be issued a warrant. It is a public safety issue that forces law enforcement to spend countless hours serving bench warrants for minor traffic violations instead of focusing on violent crime. It is a budget issue, as it is the taxpayer who pays the courts to file warrants, law enforcement to enforce them, and jails to house those who are arrested on these warrants. It is a public health issue, as potential medical students who live in Nevada may have criminal records due to minor traffic violations that candidates from other states do not have, even though they committed the same traffic violation. This puts our candidates at a disadvantage, favoring those who are more likely to leave the state after graduation. It is a child welfare issue, as a single parents who are forced to spend the weekend in jail for a traffic warrant are in danger of losing custody, at least temporarily. We understand that the transition from criminal to civil may be challenging, But we as a state are up to the challenge. The sponsors and stakeholders are all willing to work with the courts to make this work. Nevada is one of only 13 states that prosecutes minor traffic violations as criminal offenses rather than a civil infraction. We are committed to working with all stakeholders to make this happen. We urge your support. Thank you very much.
Thank you for your testimony, Mr. Shepek. BPS, let's go to the next caller, please.
Our next caller with the last three digits of 318. Caller with the last three digits of 318. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary. This is Kendra Birchie, KendraBertschy with the Washoe County Public Defender's Office. I want to thank Vice Chair Nguyen as well as Chair Yeager for all of your work regarding this bill and decriminalizing traffic tickets. This legislation will impact all citizens in Nevada. It is more likely for someone to become involved in the criminal justice system and swept up in mass incarceration with the more contacts they have with law enforcement and our system. This will break that cycle for individuals who shouldn't have been involved in the criminal justice system in the first place. 37 states, according to the Nevada Independent, do not treat traffic tickets as criminal offenses. Our state can become one of them. The current penalties and threat of jail time that result from traffic violations should be reserved for serious criminals that endanger the safety of our citizens, not for someone only going 5 miles over the speed limit. Between July 2017 and June 2019, over 38,000 Nevadans had their driver's license suspended because they could not afford to pay court fines and fees. Without the license, many Nevadans lost their ability to work, care for their children, or access basic needs. I agree with the statements that were said before me, and I believe that with this bill, we've been able to strike a balance that will enable courts to have sufficient teeth in order to ensure that people are able to pay for the fines and fees, while also ensuring that Nevadans can continue to become and be productive citizens of this state. Thank you so much for your work on this bill, and thank you for the time and attention today.
Thank you for your testimony, Ms. Birchie. BPS, let's take the next caller in support, please.
Our next caller with the last three digits of 130. Caller with the last three digits of 130, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINE SAUNDERS. I'm a policy director with the Progressive Leadership Alliance in Nevada in support of Assembly Bill 116. For many people in Nevada, the first step into the criminal justice system is a traffic stop. And because Nevada's traffic tickets are currently criminal violations, something as seemingly harmless as a broken taillight or unpaid parking tickets could lead to your arrest, incarceration, or as you've already heard this session, the suspension of your license. Often the fines associated with these criminal penalties are outside the economic means for many Nevadans. A recent report by the Edelman Financial Engines found that nearly half of American households with incomes less than $50,000 report having no money set aside for emergency. Similarly, when households in this range were asked how they would cover a $400 unexpected expense, only 41% said they would pay it in cash or pay it off on their next credit card statement. The rest said they would resort to borrowing, debt, or raiding their retirement savings, and 1 in 5 said they would be entirely unable to come up with the money. By making minor traffic violations civil infractions, we remove overly harsh punitive measures and prevent the physical, emotional, and economic harm that being incarcerated can have, such as losing employment and housing instability. Since 1970, at least 22 states, including most of Nevada's neighbors, have already taken the step to decriminalize minor traffic tickets. We believe it's time for Nevada to join them and urge your support.
Thank you for your testimony, Ms. Saunders. BPS, let's go to the next caller, please.
Our next caller will be caller with the last three digits of 630. Caller with the last three digits of 630. Please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last three digits of 630. Press star 6 to unmute yourself, please.
Good morning, Chair Yeager, and members of the Assembly Judiciary Committee. I'm Caleb Green, CALEB, GREEN, and I'm representing the Las Vegas chapter of the National Bar Association, also known as LVMBA, in support of AB 116. I want to start my remarks by reiterating a point I believe that this committee would agree with, which is that our criminal system should be rehabilitative, if not punitive. However, under the existing laws, citizens are unjustly and disproportionately punished with financial penalties that, if go unpaid, render stiff criminal consequences. Ultimately, we believe that AB 116 eliminates the financial and criminal tax on the disenfranchised while addressing the disparate treatment of racial minorities in low-income families. To illustrate, I want to share a brief story about how the current laws impact everyday people. The very first pro bono case that I had the opportunity to take on involved representing a young man and quashing a warrant issued by the city of Henderson. Now, this young man had been cited at the age of 19 for something as minor as jaywalking. However, he had no job and no means of paying off that citation. And like many other people, that citation lapsed into a warrant, and he was later incarcerated for other minor traffic violations. Not only that, but this outstanding warrant also barred him from passing background checks that would have allowed him to secure gainful employment necessary to support his family and ultimately settle the outstanding citation and additional administrative warrant fees. This exemplifies that under our current laws, our system remains unjustly punitive and disproportionately impacts racial minorities and low-income families. The LVMBA believes AB 116 will mitigate the real-world consequences of systematic racism and class discrimination existing in our criminal justice system. As such, LVMBA urges our elected officials to please support AB 116. Thank you.
Thank you for your testimony, Mr. Green. VPS, let's take the next caller in support, please.
Our next caller will have the last three digits of 606. That's caller with the last three digits of 606. Press *6 now to unmute yourself. Please state your name and spell your name. You will have 2 minutes and may begin. Caller with the last three digits of 606. Hit that *6 button to unmute yourself, please. All right, we're going to move on to the caller with the last three digits of 541. Caller with the last three digits of 541. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon. My name is Ron Najarro. That's Ronald. Last name Najarro. And I represent Americans for Prosperity, Nevada. Chairman Yeager and members of the committee, thank you for this opportunity to testify here in support of AB 116, a bill that ends criminalization of minor traffic violations and aligns Nevada with the practices of most other states. AB 116 will change minor traffic violations from criminal to civil infractions, which would end the practice of issuing warrants when fines cannot be paid. We are only one of 13 states that prosecute minor traffic violations as criminal offenses rather than civil infractions. Major violations, and this is important, such as drag racing, reckless driving, and DUI, would still be considered criminal under AB 116. Requiring law enforcement to execute warrants for unpaid traffic tickets distract them from activities that improve public safety and can unnecessarily rob individuals opportunities to improve their lives, particularly those already struggling. Such actions waste time and resources, lead to unnecessary contact between citizens and police, and can erode trust between law enforcement and the communities they serve. Furthermore, warrants are counterproductive and an expensive method of coercing people to pay for a traffic ticket. According to the Fines and Fees Justice Center, the average person arrested in Clark County on traffic warrants spends almost 3 days in jail at a cost to taxpayers of over $400 per day. This cost to taxpayers quickly adds up, and these expenditures do nothing to improve public safety. The reality is that most unpaid traffic tickets are a consequence of, one, a valid inability to pay, or two, simply a matter of an individual forgetting the date their payment was due. For these reasons, we support efforts to introduce an amendment allowing for community service options to pay for fines and fees and basing these options on income. The harm 3 days in jail can have on individuals and their families can range from losing a job their housing, and even their children, making it far more difficult to earn the money to pay their court debt or care for themselves and their families. Lastly, we should be funding our court system on fines and fees. Courts and the judicial system are a core function of our government. They should be funded wholly as possible from the general fund and not on the backs of those experiencing economic hardship. On behalf of our over 96,000 activists statewide, we urge you to support AB 116. Thank you.
Thank you for your testimony, Mr. Najarro. VPS, let's take the next caller in support, please.
All right. The next caller with the last three digits of 734. That's caller with the last three digits of 734. Please press *6 to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes.
Hi, this is Sherry Royster. It's SHERRIE-ROYSTER. I am calling in my capacity as the Legal Redress Committee Chair for the NAACP. I'm calling to support 116. Thank you for everyone who's already given such great testimony. I echo a lot of that testimony. I also want to look at the intent of the statute itself, the intent of imposing fines for traffic violations. We will inevitably have to go back and at some point correct the language to figure out how payments will go to different municipalities. But I want to look at its intent. The intent is to protect the community and to protect the citizens from certain driving infractions. That can still be done by making it a civil penalty, as opposed to a criminal crime. There is no doubt that lower income communities, which sometimes tend to have higher crime rates, are also policed more. And because of that, there's a disparate impact, disparate treatment in terms of those who are being deemed criminals under the statute. I know that some people have already talked about certain licenses as well, such as medical license, but we also have to think about college applications. We are at a place now where they ask you to include criminal offenses, even misdemeanors. We're also having to think about licenses like attorney licenses, where they also want you to include criminal offenses, including misdemeanors. Removing this, as other states and jurisdictions have done, will benefit the community in Nevada and those who come in and those who leave to go do great things outside of Nevada. I think that by making it a civil matter where you still have to pay fees, it still has the same impact of deterring minor infractions for driving. So I'm calling in to support 116. Thank you.
Thank you for your testimony, Ms. Royster. VPS, let's go to the next caller in support, please.
Thank you, Chair. Would the caller with the last three digits of 967 please press *6 now to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chairman and community members. I'm sorry, can everyone hear me? Okay.
Yes, caller, I can hear you.
Awesome. Thank you so much for allowing me to take the time to speak on AB 116. I just personally want to share my testimony in support of AB 116, as I really would hope that it would bring individuals who have encountered such harsh things like myself with having to deal with being arrested just for a traffic violation. I actually got arrested when I was about 6 months pregnant, driving to a high-risk pregnancy appointment. So if you can imagine, I was in jail for the first time for a traffic ticket, 6 months pregnant, and had to stay there for 17 hours to get bailed out for $380, 17 hours later. Not only that, I am an individual who has a bachelor's degree and 2 master's degrees and could not get into a particular agency in our state because I still had that on my record. And today it still affects certain opportunities that I would like to pursue, despite how highly educated and how much experience I have. It's just very discouraging. And I want to just kind of point out that there's this misconception that just because you have one traffic violation or just because you have one arrest with a traffic violation that it does not impede on your future opportunities. And I just want that to be actually addressed and noticed that it actually does. Thank you.
Ma'am, before you hang up, could you state your name for the record, please?
Yes. Sorry about that. My name is Laniqua McLeod, Laniqua. Last name is McLeod, is CCLOUD.
Thank you for your testimony, Ms. McLeod. BPS, let's take the next caller, please.
Thank you, Chair. Our next caller will be the caller with the last three digits of 706. That's caller with the last three digits of 706. Please press *6 now to unmute yourself. State your name and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the community. My name is Eddie Diaz, EDDIE-DIAZ. Thank you for this opportunity to testify in support of AB 116, a bill that ends the criminalization of minor traffic violations and aligns Nevada law with the practices in most other states. The LIBRA initiative exists to advance the principles and values of a free and open society to empower the Hispanic and Latino communities so it can try to contribute to a more prosperous America. The LIBRA initiative supports AB 116 because members of the Hispanic and Latino community, many of whom have lower incomes and less job security, would be among the greatest beneficiaries of this change. No one benefits from a system where the cost to taxpayers from unpaid traffic tickets are compounded through incarceration. If our laws can be reformed in a way that improves collection, reduces costs, and keeps people out of prison, it ought to be a no-brainer. The fact that 30 longer prosecute minor traffic violations as criminal offenses affirms of this policy change and proves that this will not harm our ability to collect these debts. We believe Assemblywoman Nguyen's AB 116 offers just that type of reform. Lawmakers in both parties should support moving it through the State Assembly and Senate promptly, and Governor Sisolak should sign it into law. Thank you so much.
Thank you for your testimony, Mr. Diaz. BPS, let's go ahead and take one more caller in support, please.
Thank you. We're now going to go to caller with the last three digits of 464. Caller with the last three digits of 464. Please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Hi, everyone. This is Courtney Jones, Courtney, last name Jones. So I have a family member that currently cannot drive their son around, grocery shop, and more because they have a warrant for a minor traffic violation. There's no reason to not move this to civil court, except if the system wants to blatantly admit that what they're doing is prioritizing money over human well-being. The community does not agree with nor advocates for the system. It's unfair and discriminatory. It's a system of power and control that, quite frankly, we can see police enjoy, being able to incarcerate people over minor offenses that have not harmed anyone, but have been made into a crime. And in my own research, I have come to see that this injustice system does not make all harms crime, and all crimes have not been made into harm. So we are incarcerating people just to keep up with a system that has never and continues to work against folks in America. People are being criminalized. This is an old tactic of mass incarceration. And when you have many Nevadans not able to pay their bail or for their car to be back in their possession, that harms their housing, that harms their, tons of things in their lives. And these fines and fees in this justice system hurts millions of Americans, entrenching them in poverty, and just continuing racial disparities and diminishing, of course, the trust that people already lack in courts and police. This is, like previous folks have said, a human cost, not just a taxpayer cost. And if we do see further into it, it's that we're trying to keep up. We're hiring more prosecutors and public defenders and judges and court staff, again, just to keep up with the system that does not and continues to not work for us. And the increase in the number and value of fines and fees, again, is just coinciding with the rise in mass incarceration. And this has been used for policymakers to justify the increased fines and fees. So that's my opinion, and I really do hope that we don't continue to use these unnecessary fees as a substitute for taxes, simply for us to continue funding this criminal and justice system. I hope we continue thinking of the bigger picture and pass this bill, because we are putting many Nevada residents in positions where they may lose their jobs, housing, children, and more. So thank you all for letting me speak.
Thank you for your testimony, Ms. Jones. And we're going to have to leave support testimony there due to time constraints. I know there were others on the phone wanting to participate today. I thank you for your patience. Apologize that we could not get to you this morning, but encourage you to submit your comments in writing. I will note for members of the committee that there are some additional letters of support on Nellis for this bill. A couple of them are from individuals. Then we also have letters of support from the Nevada Immigrant Coalition and the Clark County Black Caucus as well. So you can find those on Nellis. At this time, I'll close supportive testimony. I will now open opposition testimony to Assembly Bill 116. I don't believe we have anybody on the Zoom in opposition, but if I'm incorrect about that, could you please turn your camera on, unmute, and let me know you'd like to testify in opposition? I don't see that happening, so BPS, let's go to the phone line and see if there are any callers who'd like to give opposition testimony.
To testify in opposition of Bill AB 116, press *9 now to take your place in the queue. We will begin opposition testimony with the caller with the last three digits of 666. Caller with the last three digits of 666, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Thank you, Mr. Chairman, members of the committee. Warren Hardy, W-A-R-R-E-N, last name Hardy, H-A-R-D-Y, today representing the Urban Consortium, which is made up of the cities of Las Vegas, Henderson, Reno, and Sparks. We're signing in today in opposition based on the rules. But it sounds like we're probably in a position like that most of the folks that signed in support are. We have met with Assemblywoman Nguyen and appreciate her willingness to hear our concerns. She actually, in her testimony, addressed most of our concerns and the things we're working on. Obviously, as the cities were a little bit concerned about how all of the bills relative to decriminalization and other things are gonna match up at the end, but we'll do our best to be supportive and try to help the legislature work through those issues. But we look forward to continuing to work with the sponsor and appreciate very much her willingness to address our concerns, most of which she's already spoken to. So thank you, Mr. Chairman, and we'll keep working on this and process this great piece of legislation. Thank you.
Thank you for your testimony, Mr. Hardy. The other day we had a 777 number. Now we have a 666 number. And so who knows what comes next? BPS, let's take the next caller in opposition.
What comes next is caller 964. Caller with the last three digits of 964. Press *6 now to unmute and slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning. For the record, my name is Mary Walker, M-A-R-Y-W-A-L-K-E-R, representing Carson, Douglas, Lyon, and Story counties. We do oppose AB 116 as written due to the financial impact of the bill. For decades, local governments have relied on the sources of revenues from traffic fines and fees to fund, in a small way, because it doesn't fund everything, but it does help with the cost to issue and dispose of the tickets. SB 116 would make local governments have to pay all the expenses of issuing and disposing these tickets, including our sheriffs and police vehicles, equipment, court time expenses, while the revenue would go to the state school distributive account to fund schools. I sincerely appreciate Vice Chair Nguyen's effort and appreciate her and Chairman Yeager's comments regarding being open to changing Section 34, Paragraph 1. I look forward to working with the sponsor to come up with an amicable resolution. Thank you very much for your time, and I hope everybody's doing well.
Thank you for your testimony, Ms. Walker. BPS, let's go to the next caller in opposition, please.
The next caller will be caller with the last three digits of 196. Caller, please state your name and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chairman Yeager, Vice Chair Nguyen, and members of the Assembly Judiciary Committee. I'm Eric Spratley, E-R-I-C-S-P-R-A-T-L-E-Y, for the Nevada Sheriffs and Chiefs Association, and pursuant to committee rules only, I'm here in opposition to AB 116, but have full confidence that this bill will arrive at a place where we are not in opposition. We appreciate Vice Chair Wynn and Lisa Mosley reaching out early on to have us as part of the discussion, and look forward to nailing this down and getting the final details worked out with her to move this forward this session. Thank you, Mr. Chair.
Thank you for your testimony, Mr. Spratley. BPS, do we have additional callers in opposition?
Yes, Chair. Our next caller with the last three digits of 241. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager, members of the Assembly Judiciary Committee. My name is Alex Ortiz, ALEX-ORTIZ, representing Clark County. Even though this is a policy committee, it is our only opportunity to express our concerns about the fiscal impact to Clark County. Therefore, Clark County opposes Assembly Bill 116 as written, only due to the fiscal impact to the county. I do want to thank the sponsor, Assemblywoman Wynn, for assembling several work groups to discuss our concerns and ideas to ease these concerns. Again, my position is only based on the fiscal impact to the county and not the policy issues discussed today. We submitted a fiscal note a while back based on the original bill, which is on Nellis. However, that fiscal note may change based on any future amendment to this bill. Once again, I want to thank the Assemblywoman for meeting with us and keeping the conversation going on this very important issue. Thank you again, Chair and committee members, for your time today.
Thank you for your testimony, Mr. Ortiz. BPS, are there other callers in opposition?
We are currently taking testimony in opposition of Bill 116. To provide that testimony, press *9 now to take your place in the queue. Would the caller as user 1, caller in user 1, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, Mr. Chairman, members of the committee. This is Chuck Callaway, C-A-L-L-A-W-A-Y, representing the Las Vegas Metropolitan Police Department. Like many of the opposition before me, I am calling in opposed to AB 116 based on the rules of committee. We definitely support the concept of minor traffic offenses being civil. The concept is great, but the question is, how do we get there? There are a lot of unanswered questions in the bill as written. There are logistical issues that must be addressed. As Assemblywoman Wynn stated, our hope is that procedures for officers in the field remain the same. As we all know, traffic violations, minor traffic violations, often lead to major arrests. Just a couple of examples of that is the case of Warren Jeffs, the child rapist who was stopped for a temporary plate on his vehicle, Timothy McVeigh, the Oklahoma City bomber, who was stopped with no license plate on his vehicle. The number one complaint that we get from citizens in our communities is traffic. They are upset about speeders in their neighborhood. They're upset about the way people are driving in school zones. And as you know, we've had 21 fatalities in our jurisdiction this year, and those are often a result of speed being a major factor in those accidents. Traffic safety is one of our number one priorities, right next to addressing violent crime. And our fear is that if this is not properly implemented, that officers will simply be spinning their wheels. We are concerned with how this bill might address the adjudication process, specifically with officers being in a position where they would have to prosecute their own civil citations. We believe that a proper system should be set up similar to the current DMV system for license revocation to address these types of violations. And I like the statement made by Assemblywoman Wynn that we would be able to submit an affidavit rather than having officers appear. Section 28 of the bill, the proof of insurance section, has language that the agency shall immediately forward a copy to the registered owner of a citation by registered mail. That could be a logistical issue for our agency to be in a position to have to track down registered owners and submit to them by mail copies of citations that were written to a driver that was not the registered owner. We also may have some data and IT impacts as we change our systems over to address civil rather than criminal infractions. I would recommend, there's a saying, the old saying that you eat an elephant one bite at a time. I would recommend that there's a time frame established for implementation, with specific pieces being implemented first, such as the adjudication process that I mentioned. And this has been a discussion since 2013. We have traditionally supported the concept. We have participated in the interim study on this, and we will continue to work with the Assemblywoman moving forward. I'm very optimistic that we can get there, because I do think that it's the right direction. So thank you, Mr. Chair.
Thank you for your testimony, Mr. Calloway. VPS, are there other callers in opposition?
Yes, Chair. The caller with the last 3 digits of 073, please press *6 now to unmute yourself and slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Dylan Frainer, last name F-R-E-H-N-E-R. I'm the elected Lincoln County District Attorney on behalf of Lincoln County. Lincoln County is in opposition. The county commissioners voted to go in opposition of this as it's currently written this past Monday. Major concerns have mostly been discussed with regards to the implementation of this bill and also with regards to the impacts to the county. I currently, through our 2 justices of the peace in our county, we handle over 3,000 traffic citations. Handful of those generally go to trial. The number one issue that I see when people come to negotiate is the points. They have issues with points going on their record, so if the points are going to stay, what we're going to see is, even if this goes to civil, is that there will continue to be a lot of people challenging these. And if the DA's offices are not involved, and I know the DA's Association wants to get out of traffic enforcement, and I don't disagree with that, but the problem that's going to arise is that you will then have, I think the last caller indicated that the sheriff or the law enforcement will be the ones enforcing or prosecuting these traffic citations. My concern is it's actually going to be the judges, because the people that are going to be calling are wanting to negotiate these to no points. We certainly here in Lincoln County, we take our traffic citations very seriously, especially speeding, because we see deaths frequently from just speeding citations. And so if someone has to negotiate these, it should not be the judge. I get these down to a parking ticket. Well, first off, we don't have any parking citations out here in Lincoln County other than handicap parking. We don't even have or traffic lights. And so we do not negotiate these down to non-moving, so that someone that is more well off can pay additional money to get a non-moving citation. And so we try to take these very seriously, and the points are an important thing and will continue to cause issues moving forward. There was questions with regards to the funding. I can tell you for Lincoln County, in the last budget session, the county budgeted that fines and forfeitures would be about $350,000 to the county. I can tell you with COVID that went down to under approximately a little over 100,000, and that caused some major issues with our budget. We have very limited income out here in Lincoln County, and our whole budget for the general fund is about $4 million. And so $300,000 to $400,000 is a big portion. It does not pay for all of our courts, but it does help to offset the cost of running the courts. I do believe that if this goes civil, I know there was discussions with collection of delinquents in the bill in Section 36. My experience, I've been in private practice before becoming the DA for 15 years, and my experience is that when you try to collect civil judgments, it is very difficult and time consuming. My office has 1.5 attorneys in it and 2 staff. Our justices of the peace are not legally trained, and they have minimal staff of 1 or 2 clerks. The impact that this is going to put on us to change our systems, to be able to do additional work, to go outside and try to collect these, is going to make it very difficult on the county. And then finally, the county is in opposition with regards to restrictions that are being placed on local authority. 1, to impose a criminal penalty, or 2, to restrict what we can charge. I know the bill currently has restrictions of $20 per mile per hour on county roads. We believe that these are county decisions and should be based upon the counties to be able to do that. Thank you.
Thank you for your testimony, Mr. Frainer, and I would encourage you to connect with the sponsor of the bill on your concerns. As you've heard, she's been willing to work with folks, so if you haven't already done that, I would encourage you to connect with her in the very near future to see if some of those concerns can be addressed. BPS, are there other callers in opposition?
If you have recently joined the call, we are currently taking testimony in opposition to Bill AB 116. To provide testimony in opposition, press *9 now to take your place in the queue. Chair, there are no more callers in opposition of Bill AB 116.
Thank you, BPS. I'll close opposition testimony. I will now open it up for neutral testimony. Don't believe we have anyone on the Zoom with us in neutral on this bill. BPS, let's go to the phone lines and see if there's anybody there who'd like to offer neutral testimony.
To provide neutral testimony on Bill AB 116, press *9 now to take your place in the queue. And we will begin with the caller with the last three digits of 938. Caller with the last three digits of 938. Press *6 to unmute yourself, and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Thank you, Chair and members of the committee. For the record, my name is Ariel Edwards, ARIELLE, EDWARDS, with the City of North Las Vegas, testifying in neutral to AB 116. We'd like to thank the bill sponsor for bringing this piece of legislation forward. We appreciate the intent of the bill, as the City of North Las Vegas is largely a minority-majority city. We are still identifying the long-term fiscal impacts of this bill. So with that, thank you so much for your time.
Thank you for your testimony, Ms. Edwards. BPS, are there any other callers in the neutral position?
To provide neutral testimony on Bill AB 116, press *9 now to take your place in the queue. Chair, there are no callers in the neutral position on the bill at this time.
Thank you so much, BPS, for helping us navigate the phone lines. I will close neutral testimony. At this time, I will hand it back over to Vice Chair Wynn for any concluding remarks on Assembly Bill 116.
Thank you. Rochelle Lynn for the record. Thank you guys so much for hearing that testimony. As you can tell, there's still a lot of work to do to implement what I think is a very good policy, and I think it is where the direction our state needs to go in. I think I've tried my best to work with as many stakeholders to get it right. And as Mr. Jones had said in his supportive testimony, we're not going to get it right. I would be naive to think that I'm even that little bit talented enough to make a perfect bill. I just know that they don't exist. And our process is meant to be dynamic and to change with our society and what is happening. So I look forward to that. I did want to put a little bit of clarification on the record. I know that at one point, Ms. Mosley had talked about, I believe it was the Las Vegas Justice Court had 58,000 warrants. And then another one of the speakers had questioned whether or not that was in Henderson. That wasn't Henderson. In fact, Henderson Municipal Court has less than 12,000 active warrants, which is still a lot of warrants. But I will continue to reach out and work with all of the stakeholders to try to address all of their concerns. At the end of the day, I want to make sure that we are, again, doing this safely, efficiently, fairly, and equitably. Thank you, and I would love your support on Assembly Bill 116.
Thank you, Vice Chair Wynn, and thank you, Youth Legislator Wong, and the others who were on the Zoom to help with questions this morning. We appreciate the presentation and appreciate you spending some time with us on this Thursday morning. With that behind us, I will close the bill hearing on Assembly Bill 116. Moving right along, we're going to go to our second bill on the agenda. I will now open up the hearing on Assembly Bill 230. Assembly Bill 230 revises provisions relating to juvenile justice. Before we take the presentation, I'll let committee members and members of the public know that there are a couple of amendments that are uploaded to Nellis on this bill. I do believe both of those amendments are viewed as friendly by the sponsor of the bill. And the sponsor of the bill is our very own Assemblyman Miller. So welcome to the virtual presentation table, Assemblyman Miller. I know you have a number of folks with you who are going to help you present. We'll give you a chance to get through that, and then I'm sure we'll have some questions. So welcome, and please proceed.
Thank you, Chair Yeager. Good morning, committee members. For the record, I am Assemblyman Cameron C.H. Miller, representing Assembly District 7 in Clark County. I appreciate this opportunity to present Assembly Bill 230 before you today, which aims to eliminate direct filing provisions in Nevada statute that require youth to be tried in adult criminal court when charged with certain offenses. Now, before we get into the details of the bill, I want to offer some context so that we're all on the same page. Direct filing, also known as auto certification, depending on the jurisdiction, refers to the process where juveniles are automatically certified to be tried in the adult criminal justice system when they commit certain crimes. Now, throughout the 80s and the 90s, nearly every state in the country adopted and expanded direct filing laws that removed children, in some cases as young as 10 years old, from the juvenile courts and exposed them to adult sentences, including life without parole. Many of these children were also put in adult correctional facilities with adults. Now, much of this legislation stemmed from the devastating narrative that a monstrous wave of mythical creatures known as super predators, impulsive, remorseless elementary school youngsters who pack guns instead of lunches, would take over. So the obvious solution must have been to lock them up as young as possible to save the world, right? Something we now identify as the school to prison pipeline. Today, we all know that narrative wasn't true, and it led to more problems than it could have ever solved. So we, the members of this committee, the members of this House, the members of this legislature, are now tasked with continuing the fight to right the wrongs of that time. Fortunately, we have the power of information from a number of research studies to use as tools to aid us in our efforts. Studies that prove mature brain development and the capacity to make sound decisions is not achieved until an individual is closer to their mid-20s. Information we've all heard before in this committee once, we'll continue to hear as we aggressively attack juvenile justice issues in our state. Now, additional research also shows incarcerated youth experience greater childhood trauma than those in the general population. So to speak on this, we will hear from Stephanie Tucker, a national board certified clinical professional counselor. Now, let's also not forget that in August, this state declared racism a public health crisis, and mounting evidence shows that direct file laws, like most other laws, disproportionately affect communities of color. Nevada is no different. From 2012 to 2017, 140 of the 147 juveniles directly filed in adult court in Clark County were young people of color, Black and brown kids. I'm going to repeat that again for the people in the back. From 2012 to 2017, 140 of the 147 juveniles directly filed into adult court in Clark County were young people of color. Jageda Chambers of Mass Liberation and Silver State Voices will provide some additional information on the racial disparities in this area. So where are we today? Well, several states have passed measures to revise their direct filing statutes, and some have even eliminated the practice of trying youth as adults altogether. Several of our neighbors have passed legislation that allows juvenile courts greater discretion when certifying youth as adults and establish more stringent standards for the certification process. Now it's Nevada's turn. Mr. Frank Guzman, director of the Youth Justice Initiative and National Center of Youth Law, who was instrumental in eliminating California's direct file legislation, will share his personal story with us and tell us the work he's doing in our neighboring states to end the practice of trying youth as adults. Now, I just briefly mentioned the school to prison pipeline before, and I'm not yet an expert in the area to know all the best ways to end it. But with my whole heart and the little bit of common sense I operate on, I can tell you one thing we can do for sure. That is to eliminate the direct route of taking kids out of school and placing them in the adult criminal justice system. We do that by leveraging the tools of information provided by the professionals that you will hear from today and those who have worked hard on this legislation. Then we must take the bold and courageous step to apply that information and pass this bill for Nevada's future. Chair, with your permission, I would like to turn the presentation over to Kelly Jones, a Clark County public defender in the Juvenile Division, who will walk us through the bill as it is written.
Thank you so much, Assemblyman Miller. Appreciate that. Ms. Jones, welcome to the Assembly Judiciary Committee, and please proceed with your remarks.
Good morning, Chairman Yeager and the members of the Judiciary Committee. Again, for the record, my name is Kelly Jones. I am a Chief Deputy Public Defender with the Clark County Public Defender's Office, the Juvenile Division. And thank you for the opportunity to speak on Assembly Bill 230. Assembly Bill 230 eliminates provisions in the Nevada statute that require juveniles to be treated in the adult criminal court when charged with certain offenses. The measure initially keeps juvenile crimes within the juvenile court, yet allows juvenile court to certify a young person as an adult when an investigation and hearing shows that it is proper in most extreme cases. Now, please keep in mind that the AB 230 does not change the existing criteria that make a youth eligible to be certified. Also remember that the primary focus of the juvenile justice system is for rehabilitation. And consistent with this philosophy, the research has demonstrated that youthful offenders retained in the juvenile system have a lower recidivism rate than those who are transferred to adult correctional facilities. With this bill, we can more fully and appropriately address and perhaps even stop circumstances that lead to concerning behavior of youth. Not allowing a child the opportunity for a second chance to redeem themselves seems to be especially and particularly cruel. Just to give you a little background, as Assemblyman Miller mentioned, taking a youth from the juvenile justice system to the adult system is quite cruel. This transfer actually takes out of the hands of the juvenile court system the opportunity for the court to actually determine, based on circumstances and behaviors of the child, and makes them actually have to send the child to the adult system. What we found is that youth that are sentenced to adult facilities are 5 times more likely to be victims of sexual abuse, 36 times more likely to commit suicide than their peers that are in juvenile facilities. What we've also seen that youth that are prosecuted in the adult system are 34% more likely to recidivate and to more violent offenses. Mandatory transfer statutes and statutory exclusion statutes tie the hands of the juvenile court judges, as I mentioned before. And also, it can work on the psyche of a child when they are placed in an adult system. In 2014, the Iowa Supreme Court struck down mandatory minimum sentencing for juveniles as unconstitutional. And also, they decided that any law that writes off a child based on a category of conduct without considering all the background and facts and circumstances was cruel and unusual punishment. Understand that our juvenile judges are actually more trained to understand and more familiar with the services that are available to you, which does not happen in the adult court. Juvenile courts are specifically created to address the individualized needs of youth, and in recognition of youth, they recognize that youth are much different than adults. In AB 230, also, we want you to realize that by repealing direct file, it does not repeal or limit the state's ability to actually recommend children for certification for extreme cases. And note that 45% of 45 states, including DC, have already have transfer statutes that allow the juvenile court judges to determine if a youth can or cannot be rehabilitated in the juvenile system. As Assemblyman Miller mentioned, the adolescent brain is not fully developed, and particularly in the area of the prefrontal cortex, which is critical to a higher order of cognitive functioning and impulse control. Youth correction professionals recognize that young people who commit crimes often come from troubled backgrounds. Studies have shown that 75 to 93% of the justice-involved youth have been exposed to some degree of traumatic victimization. They have witnessed violence, and they're more likely to have emotional, behavioral, social, and academic problems. This emotional and physical trauma can inhibit effective adolescent brain development. Youth who are traumatized are more likely to cope with it by becoming aggressive and fighting back. However, youth correctional facilities across the country have been successful at rehabilitating youth. There are several programs out there that have provided results that we could actually replicate here in Nevada. And also, as Assemblyman Miller mentioned, it was based in the 1990s of the super predator that got us these laws. They're basically saying that we are writing off children and believing that they are more like adults than children. We are criminalizing their behaviors, which is absolutely unnecessary. There have been several jurisdictions that have removed youth under the age of 18 out of adult jails, allowing them to remain in the juvenile system and juvenile detention centers. We know that there is quite a bit of emotional stress on juveniles when they're placed in adult jails. One case that comes to mind that's happened in the last 10 years is Khalifa Browder. He was a youth who was accused of stealing a backpack. He was on Rikers Island for 3 years in that adult system without ever being charged. That was at the age of 17. When he was released in 2014, he had massive trauma. He could not sleep, was always concerned about what was going on around him, thought he was going to be jumped in the subway system. And in 2015, he committed suicide. This shows you the impact of what being in an adult system can do to a child. So today we are asking that you support AB 230, eliminate direct file, allow youth to remain in the juvenile justice system, and to have an opportunity to have their due process of a certification hearing to determine, based on their background, their emotional and psychological needs, of whether or not they can actually be served in the juvenile system. Thank you.
Thank you for your testimony, Ms. Jones. I believe we're going next to Ms. Tucker. Is that correct, Assemblyman Miller?
Yes, Chair Yeager. Assemblyman Miller, for the record, yes, we'll go to Ms. Stephanie Tucker and then to Jagada Chambers.
Thank you so much. Welcome, Ms. Tucker. If you wouldn't, I don't know if you have camera capabilities. If so, if you could turn your camera on. If not, just feel free to proceed with audio only. Welcome to the committee, and please go ahead.
Hi there. It actually says that I can't turn my camera on because the host stopped it. I do think I came in with my camera on, so that might be the issue.
Thank you. We'll see if we can get that resolved in some fashion. There we go. So we have you on camera now. Please go ahead.
All right. So my name is Stephanie Tucker. I'm a clinical professional counselor and a national board certified counselor. I went to UNLV and actually you can see it right there. I did counseling psychology there. So I want to tell you that right after I got out of school, my first assignment to work in was people who'd been through the court system. These were court mandated counseling clients. And the vast majority of them just broadly kind of showed signs of post-traumatic stress disorder, hypervigilance, anxiety, panic attacks, a lot of depression, suicidal thoughts, intrusive thoughts, things like this. And many of these people had been through some kind of juvenile court system, but also many of them had actually been taken to jail or taken to adult jail as kids. And I just want to tell you that, like, it's not just my personal, anecdotal experience here, but in fact that, like, people who are jailed when they are minors, they are much more likely to be adults with post-traumatic stress disorder, various mood disorders, and trauma-related stressors. And as Ms. Jones, who was speaking previously, alluded to, the prefrontal cortex of a minor is not totally developed. And in fact, we don't think that it's completely developed till around age 25 for most people. So while we are putting many of these people in jail, they are developmentally immature. And I think anybody who's kind of been around teenagers or remembers being a teenager themselves will know that, like, maybe the choices and decisions that you made as a teenager are not the same ones that you would make as an adult. There's a study done by UCLA, shows about 66% of juveniles who enter adult jail, probably most likely, this is a study done of about 14,000 people, have some sort of undiagnosed mental illness. And it also shows that aggressive punishments like jail time actually worsen those things. And this is maybe where I want to, like, kind of bring in the concept a little bit of, like, epigenetics. So epigenetics, you can kind of think of with mental health, sort of like you might think about cancer. We might have a predisposition to have some kind of a problem, right? Maybe it's trauma-induced stressor problems or depression because we have some genetic factors. But really what causes mental health problems are the interplay of both genetics and environment. And when these two things kind of come together, we kind of get like the perfect storm of difficulties with mental illness. And one of the reasons I want to talk about this in particular is because I want to talk about the ACEs scale, which is something that you may or may not be familiar with. ACEs stands for Adverse Childhood Experiences. Adverse childhood experiences are really, really important. And I think a lot of people think, oh, well, this happened in childhood. It's not as important as it is today. Maybe they don't know much about developmental theory, but a very long time study and longitudinal studies have shown that adverse childhood experiences, one of the most adverse childhood experiences being taken away from your parents, removed from your family, being abandoned and or witnessing like violence, which can also be the result of being arrested for many people. It is typically a very emotionally charged and violent thing to be arrested and to be taken away from your family and put into the court system. This causes a ripple effect of problems far beyond what is happening currently with a child in that system. And I tell you that because what we see with ACEs, adverse childhood experiences, is that those people actually grow up, and I want to appeal to you kind of fiscally here. These people grow up to be people who have mental and emotional health problems over the entirety of their life. And when I say physical health problems, people who have adverse childhood experiences, they grow up to be people who have gastrointestinal problems, back problems, chronic headaches, things that they are visiting doctors for frequently. And the other portion of that is also that they grow up to be people who are more likely to have mental health problems. They're also much more likely, as Ms. Jones also alluded to commit suicide, to have depression, and they are much, much more likely to be entangled over a lifetime with both mental health and psychiatric services like hospitalizations. I do want to maybe hit on the fact that kids are also disadvantaged in the system. When we put children who, again, their brains are not completely developed until after age 25 into a system where they are expected to act and make decisions the way that an adult might, they are highly disadvantaged. They're highly disadvantaged in the fact-finding process because they occupy a lower social status. So when we're interrogating children, and of course I know there's also AB 251 in the works here too, but we're interrogating children or asking them these questions. Many times we have to recognize that children occupy a lower social status. They may say or do things that adults wouldn't do. And unfortunately, once they go into prison systems, they are expected to make choices and decisions the way an adult might. And that is actually just not pragmatic. As all of us know, like there are certain things that we don't allow kids to do because they're not developmentally ready to do them. I mean, some examples of that, of course, are like drink alcohol, drive a car. So in this case, we would be putting people who we don't trust enough to drink alcohol, for instance, responsibly, but we would expect them to be able to make responsible decisions about their own lives and the future projection of their lives in a prison system. I have to say, there's been a multitude of studies that both show that there are, of course, impacts beyond the incarceration for a lifetime over this, and probably you've been presented with a lot of them. But I think maybe the important piece to take away is it's not just that the person is disadvantaged, but like the person is disadvantaged and it's something that all of us have to deal with, whether it's them getting arrested later on, them needing a greater amount of social services, mental health services, physical health services. This actually is a bad thing for everyone to incarcerate children. And as Ms. Jones alluded to as well, there are better outcomes for keeping people inside of juvenile systems. And I appreciate you listening to me this morning. Thank you for giving me your time.
Thank you for your testimony, Ms. Tucker. We're going to go next to Mr. Chambers. Mr. Chambers, if you'd like to turn your camera on, unmute, and provide your testimony, please.
Greetings, committee members. Thank you, Chair Yeager. Thank you, Vice Chair Nguyen. My name is Jageda Chambers. I'm an 89113 zip code person. I'm a Clark County School District father. I'm a Mass Liberation Project fellow. In my day job hat, I'm the Rights Restoration Coordinator for Silver State Voices. I want to acknowledge my privilege. My birth father was in my home his entire life for me. Definitely impacted my life and way of life in a positive way, and definitely how I personally approach the sacredness of fatherhood. While I'm in this space with you today, 22 years ago tomorrow, actually, during a spring break trip to Florida, my senior year of college, I got into a physical altercation with a close friend of mine, and that trip culminated with me losing at jury trial and being convicted of second-degree attempted murder. In the early stages of my incarceration, there was a 14-year-old youth that was a national story. His name is Lionel Tate. He was sentenced to natural life in Florida for the murder of a six-year-old girl he injured doing wrestling moves. Again, as I was helping build the library at the annex facility where this youth was housed, I would see Lionel regularly. The gentleman was never in a hurry. He was always walking with his head down. And as hard as prison was for me to digest at 22, actually in my early 20s, it used to plague my spirit when I saw that youngster. I think therein lies my passion for youth. It had a huge, profound impact on me. Youth in conflict with that come in conflict with the law should be treated fairly and definitely not treated as adults. I think my purpose is assisting the mothers and the grandmothers who navigate those kids through the criminal justice system. But my hopes in that work is showing those youth it's a better way than what they're entangled with now. I'll dig right into Assembly Bill 230. I'm going to divulge some of the realities as to Clark County's usage of direct filing a youth into the adult court system. The data will highlight racial and ethnic disparities that are troubling, to say the very least, and some would say are, to be honest, a civil rights. Again, this portion by commending Clark County's Department of Juvenile Justice Services. They have consistently prepared reports that tell the ugly truth. And I do think that is commendable to put that data to paper instead of camouflaging it or trying to hide it. And I also want to salute our allies to the north, especially the comrades in Washoe. This is a state issue. They've been stakeholders in it throughout and making sure we have a whole state approach of how we can navigate through this. Since 2013, there have been over 200 youth directly filed into the adult court system in Clark County, and 90% of them, to be honest, are kids of color. Black youth, who have routinely hovered around 10% of the youth population in Clark County, they make up the undeniable majority of the direct files. For instance, of the 219 total filed since the report of 2013, 131 of those are Black youth. Combined with 68 of the 219 being Latinx youth, that'll make 199 of 219 of the uses of direct file falling into youth of color. Direct files real time is during our election work this year, we came in contact with a family. A 14-year-old was charged with murder and direct filed into the adult court system. In meeting and spending time and getting in a relationship with his mother, it was 3 youth who were friends. That firearm accidentally went off, and the gentleman who lost his life, his father, had made acknowledgement of that immediately on social media and to the appropriate authorities, but yet that 14-year-old is dealing with the reality of being charged with murder and being housed in Clark County Detention Center now. I think me personally, what drove my dedication to the issue was the grim reality of 2017. The report showed that all 41 of the youth filed into the adult system filed into the adult system that year were youth of color. Again, of the 41, 27 were Black youth. And at this point in 2017, the Black youth made up in the whole of Clark County's population right around 9%. So needless to say, I just got invested into the information. What we can do to change this has been a collective effort, and I'm proud and honored to have been in these workspaces and to be considered a stakeholder. But I know truthfully that I'm a stakeholder by product of these mothers who are and grandmothers and parents who are enduring this personally. I do want to admit in 2017, when it did become an issue, myself and Mass Liberation Project lead organizer Leslie Turner, we were able to acquire a meeting with the district attorney's office. We wanted to dig into the direct files. We wanted to know kids' literacy level. Were the children in foster care? Did they commit their crimes with adult co-defendants? You know, a lot of the stuff that should go into place, and to be fully transparent, none of that stuff was available. Record keeping was almost prehistoric at that stage. I know it has taken on some strides in the right direction. But even the arresting agency, I think all those play a part. So we wanted that information, and again, it wasn't able to be made available. In conclusion, I'll just say that what's most alarming to me today, March 2021, is that dating back to 2012, Clark County personally had never direct filed a girl. A young girl had never been thrust into the adult court system. And to be honest, over the last 2 reports, there have been 12 young girls now thrust into that adult court system. I'm not trying to say girls are more precious than the boys, but if that don't kind of sit wrong with you, I think there are other issues at the table. So again, I don't want folks to think that all these kids are murderers, and a lot of other stipulations fall into place with a kid falling into that adult court system. And it goes without saying that it's time for us to end the practice. I'll say that much and surrender back to you, Chair. Thank you, sir.
Thank you, Mr. Chambers. Appreciate you sharing your personal experience with us. I'm going to hand it back over to Assemblyman Miller, who I believe has some additional comments.
Yes, thank you, Chair Yeager. And it's Assemblyman C.H. Miller for the record. The intent and goal of this bill is to eliminate direct filing, period. I want to be very clear. That is my ultimate goal, and I am fully committed to it. Hard stop. To accomplish that goal, we have some infrastructure delinquencies that create gaps between the current jurisdiction of the juvenile system and the adult criminal system. So there are 2 amendments that will allow us to make a significant step forward while also gathering information we need to close those gaps. So our children can live, grow, and prosper in a Nevada where all children are able to remain children. Chair, at this time, I would like to turn the remainder of the presentation over to Bridget Duffy from the Clark County Public Defender's Office, who will present on the Clark County, the DA's amendment. She will be followed by Holly Wellborn, who will present the ACL submitted amendment. And then we will close out with Mr. Frankie Guzman, and then we will be ready for questions. Thank you.
Thank you so much, Assemblyman. Ms. Duffy, welcome to the Assembly Judiciary Committee, and please proceed when you're ready.
Good morning, Chair Yeager and members of the Assembly Committee. I am Bridget Duffy, spelled Brigid Duffy. I am the Chief of the Juvenile Division for the Clark County DA's office, although oftentimes I go back into juvenile detention and children want to talk to me, and I tell them I'm not their public defender. I think Assemblyman Miller just bounced me over to the public defender's office in my introduction, but I am actually the Chief of the Juvenile Division for the District Attorney's Office. And today I'm appearing on behalf of the Clark County District Attorney's Office. I'd like to start my presentation by walking you through the amendments that have been considered friendly and are available on Nellis. In Section 1, we are asking to restore the original language to statute. In Section 2, the amendment would restore subsections 3A, D as in dog, E as in elephant, and F as in Frank to 62B as in boy 330. We would continue to strike subsections B and C. And I'm going to pause there and let you all understand what subsections B and C are and the recommendation to remove those from direct file or auto certification. So subsections B and C. B is a sex assault or an attempted sex assault involving the use or threatened use of force or violence against a victim, and then any other offenses, related offenses rising out of it. If the person who committed the offense was 16 years of age or older, and before the sex assault was committed or attempted to be committed, they had previously been adjudicated, or in terms some may understand better, have been found guilty of a prior felony. Subsection C is an offense or an attempted offense involving the use or threatened use of a firearm. So most commonly in Clark County, these are offenses which involved armed robberies. And that child would have been 16 to 17 years of age and would also have had a prior adjudication of a felony or a prior felony conviction on their record. So the District Attorney's Office is supportive by policy of striking B and C, and I will get into that more in my support testimony. We are asking to restore Section 3 to its original language. We are asking to remain Section 4, which would be the removal of all presumptive certifications. So a presumptive certification for 16 and 17-year-olds, for those who do not practice in the legal field, would be the court would go into the argument presuming that he needs or she needs to send this child to the adult system, and then the child would show the burden of why they should not go. We are asking to have that remain out of statute and allow all certifications to be at the discretion of the court. Section 5, we would restore to the original language, and Section 6, we would restore to the original statutory language. Those restorations in Sections 1, 3, 5, and 6 are just references back to 62B 330 because that section would not be stricken in its entirety. So I thank Assemblyman Miller for reaching out early, very early in this process to start this conversation, because this was not a conversation you could have with a bill drop and 24 hours to a hearing. This involved a lot of conversations around a very important and significant piece of legislation. And there is no mistake that I am a prosecutor by title, that I am charged with public safety, as my main priority. I sought my service, my public service profession, because I wanted to help my community and keep my community safe. And I do take that oath and my responsibility seriously. My family wasn't thrilled about my choice of profession at first. I think it was something about them being afraid that if I handled too many child abuse and neglect cases, my soul was going to break. But instead, it actually gave me the strength to look at the system, which I am an important part of, and ensure better, stronger lives for all children, no matter the trauma or circumstances that are often out of their control and that they just find themselves in. In 2012, the District Attorney, Steve Wilson in Clark County, honored me by placing me in a position to run the entire juvenile division, not just the foster care section of that division. And for 9 years, I've supervised a team of district attorneys that prosecute juvenile delinquency, which is prosecution of children. And that is what brings me to the table today. Assemblyman Miller brought me an opportunity to balance the rights and protections of victims, who are often also children, with the ability to find opportunity to help a child who is making some serious, egregious, and dangerous choices, help that child get placed on the right path to a positive future. I want to be very clear to this committee and to the public who is watching. The delinquent act, or what may be better known as a crime, will still be prosecuted, or may still be prosecuted. Robbery with use of firearms is a very serious offense, especially a gun in the hands of the child. And it leaves lasting trauma on my victims, changing their lives forever as well. What this amendment to AB 230 will require is only that now prosecutors must choose to file a motion to certify those children as adults for those crimes, and therefore allowing those 16 to 17-year-olds who have had prior felony adjudications, again, easily thought of as prior, a felony record, that might help. They have a felony record. Those children must first go before a juvenile judge, and the juvenile judge will determine if the child may be treated and rehabilitated in the juvenile system, or if they should be transferred to the adult criminal system. These statutory sections being removed will mean they will not automatically go to that adult criminal system. In closing, I emphasize that keeping our community safe is my #1 priority, and the amendments to AB 230 is an opportunity, I believe, to improve community safety by allowing those children who commit terrible acts a chance at rehabilitation and services in the juvenile system. A treated, rehabilitated child, a child that receives an education, job training, counseling, and becomes an adult that can possibly go and live a good life and not continue to victimize our community. The juvenile prosecutors across our state hope that these children will embrace that opportunity and that is provided to them and change their trajectory. I would like to just clarify some comments by my friend, Mr. Chambers, who I adore and I've enjoyed working with over the past years on juvenile justice reform. A 14-year-old, we cannot direct file 14-year-olds to the adult system. We have not been able to do so. I believe it was a 2013 legislative session and went into effect in 2015. So that 14-year-old would have been a certification, not a direct file. I'm not sure how old that case is. But we do not direct file 14-year-olds. They go through the court, and it is the court's discretion. It is a discretionary one. As to the 12 girls, I do not have a direct file on a female. Those would have also all been certifications, to my knowledge, and I run the division, that would have gone before a juvenile judge prior to going before into the adult system. So they would have had that opportunity. I truly appreciate the opportunity to be here this morning, and I look forward to any questions that you may have of the juvenile district attorney, not public defender, Assemblyman Miller. But I might get that reputation after today's hearing.
Thank you so much, Ms. Duffy. Just before we move on to additional testimony, we are going to be really running short of time given the length of this presentation. So I wanted to ask you just a quick clarifying question while I had you here, just to make sure that we're all on the same page with the bill. So the original Assembly Bill 230 would have eliminated all direct files of certain juveniles, period, so that there would have had to be a motion filed and a judge would have had to essentially sign off on the certification. And I believe what your amendment does is it reserves a few categories of offenses that can still be direct filed into the adult system, but the remainder of those offenses would have to go through the court process for certification where a judge would make the call. Could you just confirm that that's correct in terms of my understanding of the amendment?
Yes, Chair Yeager, this is Bridget Duffy for the record. That is absolutely right. You're saying it just a different way. So it would remain categories of murder and attempt murder for 16 to 17-year-olds. It would remain what I refer to as a Parkland or a Columbine type event, which would be a mass casualty situation or an attempt at a mass casualty situation on school property. And then it also maintains what we call gap cases, or those children that we cannot, that are now adults, so they commit offenses at 16 or 17, and we do not have them identified or in custody until 20 years, 3 months, or 21 years of age. And remember, we lose jurisdiction in juvenile court at 21, so there's not much we can do rehabilitatively there. So it preserves 3 sections, and the importance of that, and I'm sure I'll get questions about it, is that infrastructure portion that Assemblyman Miller spoke about. Our jurisdiction only goes to 21, and we only have 1 locked juvenile facility, and our facilities are only designed to be 6 months length of stay on average.
Thank you for that. And then the one follow-up question I have was just a numbers question. Are you able to give us any sort of context about, the kind of cases that are still going to be able to be direct filed were this bill to pass with the amendment? Like, what are the numbers of that based on? I hope I'm asking that question right, but I'm just kind of wondering, with the changes that we're making, how many kids are we talking about who would now get a certification hearing that wouldn't if this bill didn't pass?
So I did the numbers the best I could based upon our statistics, and Mr. Chambers had alluded to it. We do not have a case management system in the juvenile division, so these are all hand kept. And so when I give them to you, you can probably figure maybe plus 2, 3, minus 1, 2, 3. So they are the best stats that I have kept since 2017. And this will impact about 60% of the direct files, or approximately 25 kids a year. I did the stats over 4 years. So on average, it's 40 children a year that are direct filed. We had a spike in 2018 of 51 kids. We had a deep decline in 2020 to 34 kids. So on average, I'm saying 40 kids, and this will impact 60% to remain in the juvenile system for a certification hearing with approximately 25 kids a year.
Thank you. And just to be clear, they would remain in the juvenile system for a certification hearing, but if indeed a judge decided certification was appropriate, they would then go to the adult system to answer to the charges.
That is correct. Oh, Bridget Duffy for the record. Sorry, I missed that last time. That is correct.
It's okay, Ms. Duffy. It's been a long week, so we certainly understand. Thank you for presenting the amendment. I think we're going to go next to Ms. Wellborn, who's going to talk about the ACLU's amendment to the bill. So welcome, Ms. Wellborn, and please go ahead.
Thank you, Mr. Chairman. Holly Wellborn, Policy Director for the ACLU of Nevada. I appreciate the opportunity to be here this morning. I will be as quick as possible, but for several of you that have been around for a while, since at least my time with this organization, I've been working on this issue since day one. And it's getting exhausting. It really is. But we move forward. We take each step. And yesterday we had a stakeholders meeting with Ms. Duffy and the community advocates who have been pushing for this legislation, and came to the conclusion that the infrastructure needs bind our hands in being able to move forward with a repeal of direct file. So this amendment, it's quite simple. It allows us to carry on this conversation. It allows us to utilize the Interim Committee on Child Welfare and Juvenile Justice. That is a committee where we can continue the conversation on a wide range of different juvenile justice issues. There's at least one member of this committee who sits on that interim commission, Assemblywoman Hansen. She did an incredible job. But that is a space where we can take time to really understand what these infrastructure needs are, what the costs are that are associated with bringing juvenile facilities up to par with, in a way that actually positively impacts youth. It would just be a very simple amendment that would add an additional section to this bill that requires the Interim Committee on Child Welfare and Juvenile Justice to conduct this study And it would allow us as community advocates, as impacted individuals, to bring in experts to talk about ways that we can improve systems in our state so we can keep moving in the direction of ending direct file once and for all. So, that's my very simple presentation, but I'm here to answer any questions folks might have. Thank you.
Thank you, Ms. Wellborn. Appreciate that. I think our last presenter to close us out on the presentation was Mr. Guzman, who I believe is with us on the Zoom. So welcome to the committee, sir, and please go ahead.
Thank you. Thank you, members of the Assembly Judiciary Committee, for this opportunity to share my remarks with you today. My name is Frankie Guzman. I'm an attorney at the National Center for Youth Law, where I lead a team of attorneys and policy advocates working to transform the youth justice systems in California, Colorado, and Nevada. We partner with state and local leaders to shift policies and practices and investments away from outdated punitive models of justice towards evidence-based, health-focused approaches to proven effective at improving youth outcomes and public safety, while also reducing recidivism and unnecessary incarceration costs to the state. I strongly support AB 230. The decision to send a young person to the adult system is the most serious decision the juvenile court can make, and one that should be made by a judge trained in adolescent development and juvenile justice best practices. Extensive scientific research shows that children are less culpable for their actions and have tremendous capacity to learn and to grow, a capacity that is wasted when youths are sent off to adult prisons. The research also shows that young people handled in the juvenile system are more likely to thrive, while those sent to the adult system are more likely to commit new crimes and new victims. If passed, this bill will improve public safety by allowing more opportunities for Nevada youth to receive treatment in the juvenile system, while ensuring that the state does not overly rely on the adult prison system for children who do not belong there. AB 230, if passed, would make important changes to Nevada law by limiting prosecutors' authority to directly file charges against children in adult court in only the most serious cases. As a result, the bill would require juvenile court judges, rather than prosecutors, to consider how children are different than adults for the purposes of prosecuting and sentencing in juvenile or adult court in the majority of cases that are eligible for transfer in Nevada. Because judges receive training, have statutory guidance, and judicial oversight around decision-making, they are better suited and more appropriate to make determinations about whether a youth can benefit from the rehabilitative programs available in the juvenile justice system. This issue is deeply personal to me. As an attorney, my work focuses on reducing the harmful practice of prosecuting youth in the adult criminal justice system. Youth sentenced in the adult system often receive very lengthy prison sentences and get little to no education or rehabilitative services. I advocate for youth to get developmentally appropriate treatment offered in the juvenile system because without it, they are more likely to fail. I know this personally. When I was 15 years old, a friend and I robbed a liquor store armed with handguns. We were arrested and received transfer hearings in the juvenile court where a judge decided whether we should be transferred to the adult system. After a hearing, a judge decided that I should be kept in the juvenile system, where I ultimately served 6 years in the state's Division of Juvenile Justice. There, I received education and treatment that I needed. When I was released, I went off to college. I thrived later in life, in part because I had a chance to be in the juvenile system. My friend, however, was not so lucky. He was removed from the juvenile system and sent to adult criminal court. He entered adult prison and his life spiraled down from there. He did not get the rehabilitative opportunities that I received. I know how much we both needed direction and help. I got it and he didn't. This issue is also important to me for professional and ethical reasons. As an attorney, my work focuses on reforming laws that impact youth charged with serious offenses in partnership with elected officials, system administrators, local courts, and community stakeholders by improving data collection and analysis to better understand the impact that criminal laws have on youth, raising public awareness of the harms of youth incarceration, improving state and local policies and investments to create effective alternatives to incarceration and punishment for youth, and working with communities most impacted by harsh prosecutions of children to improve justice for all. As such, I had the privilege of partnering with California Governor Jerry Brown and a broad coalition of system and community stakeholders, including leaders in law enforcement, faith, labor, and justice-impacted communities of color to pass a ballot initiative or referendum that ended California's direct file law entirely. the California electorate passed that measure by 65% in support. In order to achieve that victory, we led a campaign rooted in lived experience, data, and scientific research. Notably, our data and research on direct file practices in California demonstrated that prosecutors use direct file despite plummeting youth crime. 80% of youth prosecuted in the adult system were placed there by prosecutorial direct file, despite a 55% drop in youth felony arrest rates. District attorneys reported 23% more direct filings per capita in 2014 than they did in 2003. These opposing trends suggest that there was no clear relationship between serious crime and the use of direct file. Also, racial and ethnic disparities had grown. While the rate of direct file was decreasing for white youth, it had increased for Black and Latino youth. For example, in 2003, Black youth were 4.5 times more likely than white youth to be direct filed, but by 2014, this figure rose to 11.3 times more likely. Moreover, between 2003 and 2016, when direct file was finally abolished, California had prosecuted more than 11,000 youths as adults. 90% of these youth were Black and Latino. Also, as noted before, of these 11,000 youth, 80% of them were placed there by prosecutors and not judges. And lastly, our data showed that county level disparities led to an inequitable system of justice by geography. We found that in addition to race, the county in which the youth was arrested was a greater indicator of whether a youth would be direct filed than was the severity of the offense. For example, Yuba and San Diego counties reported identical rates of youth arrests for serious offenses, but youth living in Yuba County were 34 times more likely to be direct filed in adult court than youth in San Diego. Meanwhile, scientific research clearly demonstrates that young people charged with serious offenses can learn from their mistakes and grow to become responsible adults if given the opportunity. For example, studies published by the federal DOJ Office of Juvenile Justice and Delinquency Prevention have shown that 94% of all youth who commit crimes, that's 94% of youth who commit crimes, even the most serious crimes like murder, will age out of criminality by age 25, corresponding with adolescent brain development, research, and maturation. Ultimately, California completely abolished prosecutorial direct file in all children's cases 5 years ago. Today, California continues to experience declining juvenile crime and arrest rates, reaching historic lows. So while many argued that direct file was necessary to keep communities safe and that without it, crime and victimization would increase, that never happened. Reflecting on our experience with direct file in California, I am reminded that if it were not for direct file, thousands of California children would have received judicial transfer hearings and an opportunity to remain in the juvenile system, to learn from their mistakes, and to grow to become responsible, productive adults, and even become lawyers like myself. Alternatively, I'm also cognizant of the fact that if I had been prosecuted under direct file laws, I would likely have been directly filed in adult court and sentenced to serve decades in prison. In short, I would not be sitting before you today. In conclusion, I would like to impress upon all of you the sad reality. All kids make mistakes. Some kids commit serious crimes. However, research has clearly shown that depending on the race of the child and the jurisdiction where they are prosecuted, some youth will receive the opportunity to learn from their mistakes in the juvenile system, while others will pay with their lives in prison. The practice of direct file and its stark racial and ethnic disparities highlights the need for more appropriate, effective, and humane treatment of youth, returning greater decision-making power to judges about which youth should remain in the juvenile system would introduce greater transparency and oversight into these important decisions. Youth sentenced in the juvenile system have access to education and rehabilitative services that they are not entitled to in the adult system. Upon release, youth retained in the juvenile system are less likely to recidivate and are better able to build greater family and community connections and to develop skills that lead to greater economic opportunities later in life. By limiting prosecutors' authority to direct file in only the most serious offenses involving youth, leaving the decision to transfer to judges in most eligible cases, Nevadans would reduce the high cost of unnecessary and harmful long-term incarceration of youth while improving public safety and expanding opportunities for adjudicated youth to engage in school, work, family, and community. Members of the Assembly Judiciary Committee, I urge your support of Assembly Bill 230. Thank you.
Thank you for your testimony, Mr. Guzman. We're going to take a few questions and then we're going to have to move on to testimony. I'm going to start the questions with Assemblywoman Cohen.
Thank you, Chair, and thank you, Mr. Miller, and to all the presenters for a very informative and important presentation. My question, I think, is best answered by Ms. Duffy. So I have a question about in NRS 62B.330, which is Section 2 of the bill, and my question is about the language we're putting back that your amendment puts back in. Throughout that section, there's reference to related offense. And if I'm reading it correctly, it's saying, so for instance, in NRS 62B.330, sub 3, 3A, it says, for the probably easiest if I just read it. For the purposes of this section, each of the following acts shall be deemed not to be a delinquent act, and the juvenile court does not have jurisdiction over a person who is charged with committing such acts. And then A is murder or attempted murder and any other related offenses arising out of the same facts as the murder or attempted murder, etc. It goes on from there. So my question is, if there's a murder or attempted murder, but that charge doesn't go forward, does the direct filing still happen on a related offense without the murder or attempted murder in play?
Bridget Duffy for the record, Assemblywoman Cohen, yes, those lesser included charges potentially or other charges. So if it's a murder that resulted from a robbery, that could still go forward in the adult system, and then any of the other charges that may be there that all happen from the same event.
Right, but even if the murder or attempted murder is no longer in play.
Bridget Duffy for the record, yes, that's correct.
Okay, thank you.
We'll go next to Assemblyman Wheeler.
Thank you, Mr. Chairman. First, I want to say, Mr. Guzman, thank you for sharing your story of how the system worked for you and didn't work for someone else. I appreciate that.
Thank you.
I believe Ms. Duffy answered my question on certification, so this should be a short question instead of a long one. Maybe Ms. Duffy can answer it, or the Assemblyman Miller. Assemblyman Miller, you said 147 cases were tried as adults in the last few years. And I'm wondering if you know how many of those were repeat violent offenders or gang affiliated.
Thank you, Assemblyman Wheeler, for this is for the question. This is C.H. Miller for Assemblyman Miller for the record. I do not know the specific details of those cases. If Ms. Duffy or one of the actual public defenders, if someone else on the call does know, please provide that information. If not, I'm sure we can maybe look into it.
This is Bridget Duffy for the record. Assemblyman Wheeler, can you tell me again what you're looking for in that? How many?
Assemblyman Miller said that there were 147 cases of kids being tried as adults. And I was just wondering, of those 147, how many were repeat violent offenders or how many were gang affiliated?
So Bridget Duffy for the record. Assemblyman Wheeler, what I can tell you is during my presentation to the interim committee, I did drill down on some numbers with regard to the direct file cases. Again, to do it myself to find out what prior services those juveniles had, how many prior cases, how many chances of probation, if they've been to our facilities in the juvenile system before even being direct filed. So we have to remember, in direct file, the juvenile court does not have jurisdiction. The prosecutors don't decide if we direct file. We do not have jurisdiction. So I drilled down on those numbers, and I do have some information, but I don't have it off the top of my head. I shared it with the interim committee, and I think Assemblyman Miller might have my little colored chart. But I also want to say that if to Assemblywoman Cohen's question, if I may, Chair Yeager, just a point of clarification, if the case goes to the criminal division on a murder and attempt murder, and they decide not to file the attempt murder or the murder, it would come back to juvenile. It would only be if it went to trial or it was negotiated that it would stay in criminal on the lesser charges if the other ones were not found to be he or she was not guilty on, or they were negotiated. But if criminal gets the screening and they say this is not attempt murder, everything comes back to juvenile. We do that. We have had that situation years ago.
Thank you for the clarification.
Yes, and thank you, Ms. Duffy. If you could get those numbers to the committee, I'd appreciate it.
We'll go next to Assemblywoman Gonzalez.
Thank you so much. Thank you so much, Assemblywoman Gonzalez, for the record. I just had a question under section, I don't know what section, but it's page 5 of the bill. When it says the child may petition for transfer of the case back to the juvenile court upon a showing of exceptional circumstances. What is an exceptional circumstance in that? Like, what is an example of that?
This is Bridget Duffy for the record. I'm waiting to see if my criminal public defenders out there are going to want to answer this question and not the prosecutor, because I don't prosecute in criminal court, so I don't know what's being argued out there.
Ms. Jones, or we have Christina Will-Devil on the call. Is this a question that you can answer?
This is a question I can answer.
Thank you.
So the process goes like this. The court does not certify if the court finds by clear and convincing evidence of the existence.
Could you please state your name for the record?
I'm sorry, Chairman Yeager. Thank you. Christina Wildeveld, Kristina, Wildeveld, Wildeveld, the record. I want to explain the process a little bit. The court does not certify if the court finds by clear and convincing evidence the existence of a substance abuse issue, emotional issue, behavioral problem, and problems that are appropriately treated in the juvenile system. The way this typically works in Clark County is when the state moves for certification, the child is then referred to a mental health professional for an examination to see if there are any of these problems, and then to see what exactly this specific child is dealing with. For instance, a lot of children are witnesses of domestic violence, or their parents recently split up, and they're acting out as a result of that. Those findings are unique to each child, and it goes back to then the court to determine whether or not those are exceptional circumstances to keep the child in the juvenile system. So it's a clinician. When you go through the certification process, each child is individually examined by a clinician. A report is then generated, which goes to the defense attorney, the state, and the court, and probation. And everyone reads through it and determines whether or not they should retract that certification petition that they filed, or they should let it go forward. And that's why I feel that every child deserves that unique look and that second look, and that no child should be direct filed. And instead, each child should be taken on a case-by-case basis to determine whether or not they belong in the adult system. I hope that answered your question.
Thank you so much, Chair. I just have a quick follow-up, if I may.
Go ahead.
Assemblywoman Gonzalez, District 16, for the record. I apologize. I don't think I said that with my first question. So I'm just curious. So if the court finds that, the child has experienced all these, hardships, what resources are being offered to the child? And if the court still has this background information and they still make the determination to go forward with the certification process, what do those resources look like going forward? Thank you.
So Bridget Duffy for the record. I will I can talk about what we have available in the juvenile system, and then, where we get exhausted on our children who commit kind of higher level offenses. So we have probationary services. We have we have trauma-informed services such as counseling, anger management. We have juvenile camps, both north and south. We have Spring Mountain Youth Camp and China Springs Youth Camp. China Springs serves girls as well. And those programs, though, are those facilities are programmatic based. So average length of stay is 6 months. They have education there. So in Spring Mountain Youth Camp, which I am most familiar with, we have the Clark County School District is there. So we have Spring Mountain High School. They have culinary program. They have a forestry program. So they have all of those like a boot camp type programs where they're actually sometimes earning money, helping step them back into the community with jobs. And then we have our state facilities, which is Summit View, Caliente, and NYTC, Nevada Youth Training Center. Caliente and NYTC are open air camp type facilities, again, programmatic based. They could be there for any, 6 months as average. Work the program, get out. We have, sex offender counseling in there, again, education programs, and technical programs like culinary. And then Summit View, which is our only locked facility, has about 40 beds right now. And then that is in North Las Vegas, and again, programmatic based, up to 6 months. So that is what the juvenile system can offer. I mean, we have a lot of services in our community. We have officers that engage with children, that are trained to deal with children. So at least, and again, I'm speaking on behalf of Clark, and I do have a lot of contact with the rest of the state. But I know our officers are very engaged with children and families and understanding child development and working with them. When a child goes to the adult system, we do have a little bit of a void, right? Because adult probation and parole officers aren't used to dealing with children. So I am often been contacted, especially with our Harbor program, from some adult probation officers looking for services for children that have been sentenced to probation in the adult court. So that's where then we have Lovelock, I believe, is where they are now sending any child that is in prison, send out as well, that talks about the outcomes of kids that are direct filed. So those kids that are direct filed that are getting probation or boot camp or are sentenced to prison. So I have those statistics as well, so you can see them. And I hope that answers a little bit of your question, and I'd be happy to follow up with you more offline.
Thank you. Yes.
Okay, I think we have time for maybe one more question before we have to go to testimony. So is there another question out there from anyone on the committee? If so, please raise your hand. And I'm sorry, my video screen is a little slow in showing me all of your faces. So if you have a question, if you wouldn't mind just unmuting and asking it, because I can't see all of you at the moment.
I have a question to just follow up on the information that was shared, Assemblywoman Gonzalez, District 16. I'm curious in terms of resources, like what therapy, counseling, you said a lot of programming like culinary and education and things like that, but if a child is experiencing harm in the home or witnessing domestic violence, what kind of psychological help is being offered to them?
Bridget Duffy for the record, Assemblywoman Gonzalez. We have the Department of Juvenile Justice Services has a clinical team. So that would be our probation department run by Clark County. They oftentimes we have full clinical assessments on children to determine what their needed services are. And then we have referral sources in the community. We have specific counseling to address all kinds of trauma that a child can endure. For our sex trafficking victims that may come in on offenses, we have specific programs that work with them and mentor them through their needs and their very complex trauma. So there is a clinical team that would determine, and we do have resources in the community to refer to.
Kelly Jones from the Clark County Public Defender's Office, Juvenile Division. Also, just to add on to what Ms. Duffy mentioned, there is also an assigned psychiatrist to the Spring Mountain Youth Camp. There are also psychiatrists that work from the community to help juveniles with different issues.
Thank you so much.
Okay, thank you. I think in the interest of time, we're going to have to move on. So I would encourage members, if you do have questions that you were not able to ask today, to follow up with the sponsor of the bill at some point. And I want to thank you, Assemblyman Miller, and all of your co-presenters who presented here this morning. I'm going to ask you to sit tight as we take some testimony on the bill, and then we'll come back to you for some concluding remarks. Given the time we're at, I'm probably going to only be in a position to be able to take about 15 minutes of testimony and support opposition, and then we'll see if there's some neutral. So I want to start with supportive testimony. I know we have Ms. Wildevelt on the Zoom with us. Ms. Wildevelt, did you want to provide testimony? And if you're able to, if you could keep your comments to 2 minutes, that would help us get through some more testifiers as well.
Thank you. Good morning, Chairman Yeager and members of the hardworking Assembly Judiciary Committee. My name is Christina Wildeveld, and I am testifying as a private criminal defense attorney. Thank you, Assemblyman Miller and Kelly Jones for bringing forth AB 230. This piece of legislation should be important to all of us. The proposed amendment does not guarantee that a child facing charges of murder or attempt murder would remain in the juvenile system, but instead it only guarantees a hearing before a juvenile judge to determine if that specific child should remain in the juvenile system or the juvenile court if you are over 16 years of age. What I'm proposing is that every child get that certification clinical examination that we had discussed. The proposed option of eliminating presumptive certification but still allowing direct file for certain charges is flawed. There are plenty of imaginable circumstances where a kid who is committed a specific crime should remain in the juvenile system despite the charges. It is not a solution even for a limited population of kids. Furthermore, prohibiting retroactive application would adversely affect those children who are currently lingering in adult prison or awaiting trial in adult court, who should otherwise have gone before a juvenile judge to make a determination if they belong in the adult prison in the first place, because there are extenuating circumstances in those cases. We believe, much like the military, in the concept of leaving no man behind. The amendment will only affect kids going forward, but leave those who currently suffer under the present laws without remedy. It is not sufficient. Nor can we not fight for those kids who should not be in the adult system, because we firmly believe that there should never be a child in the adult prison. And if there are, it should only be for very, very limited circumstances. Such a proposal is inherently unfair. Nevada cannot wait another 2 years for another legislative fix to demonstrate the compassion for this population of youth who may one day be eligible for relief. To do that would defeat the purpose of this bill. The bill in front of you, Assembly Bill 230, eliminates presumptive certification with the amendment, but still makes those facing murder charges be directly filed into the adult court. There is scientifically very little difference between a 15-year-old and a 16-year-old. Therefore, if a juvenile finds himself in a situation the day after their 16th birthday or having committed a certain offense, they will lose that protection of going before a juvenile judge. All juvenile offenders are unique in their ability to be rehabilitated. The group of kids this bill would apply to committed crimes, but they were committed as juveniles, and this bill must give them a chance at being kept in the juvenile system. It's not a guarantee. It's allowing that clinician to put forth their exceptional circumstances for each individual child and make that determination if they could be rehabilitated in the juvenile system, or in fact they need to go to the adult court to face the charges that they're facing. As somebody with extensive experience working in the juvenile justice system, I can attest to the fact that our system still needs improvements. We encounter kids in the juvenile system that are often experiencing great crisis in their life, not only because they're dealing with ordinary juvenile issues, but also issues that include homelessness, substance abuse, and undiagnosed, untreated mental health issues. This is true of any child, and even those up to the age of 21 to 25, but most certainly those children under 18 years old. Children are brought into custody for everything, including a fight, graffiti at school, or homicide. The
Ms.
age.
Weldevelt, could you please wrap up? We're way beyond 2 minutes.
Thank you. And I will leave it with that. And I urge you to support AB 230 without the amendments. Thank you.
I guess I want to be clear on your testimony. The bill was presented with 2 amendments that are considered friendly amendments. So are you opposed to the way that the bill was presented? Because it seems like you want the bill as drafted, but I don't think that's the way it was presented today. So I want to be clear on the record what your position is.
Thank you. I just want to give consideration and echo Ms. Duffy had already indicated and Ms. Jones indicated, and what Assemblyman Miller indicated, is that Assemblyman Miller indicated that he wanted this to include all children, and that's what I'm echoing. Thank you.
Thank you. I guess I'll characterize that as supportive testimony. I don't know that that fits in the committee rules, but if your position is that you support it as presented, you'd like it to go further, but you'd prefer to see it pass rather than not, then I think that would be supportive.
Thank you. I would have wrapped that up. Thank you, Assemblyman.
Okay.
Yeager.
Thank you. Thank you. We're going to stay on the Zoom in testimony and support. I think we have Mr. Jones and Mr. Pirro with us. We'll start with Mr. Pirro, please.
Thank you, Chairman Yeager. John Pirro from the Clark County Public Defender's Office, also testifying on behalf of the Washoe County Public Defender's Office. I'm going to make it brief because I want the impacted community to have a chance to testify over the telephone. Direct file harms children. This bill goes in a long measure to help children, and we urge you to pass this bill.
Thank you, Mr. Pirro. Very well done. Mr. Jones? Mr. Jones, we're having that audio issue with you, your computer again. Okay, Mr. Jones gives a thumbs up, so I think he is in support, and we'll go from there. Sorry about that, Mr. Jones. Is there anyone else on the Zoom who is in support? I finally got everyone on one screen, so that means that someone must have dropped off the Zoom. So I don't see anyone else on the Zoom in support. BPS, let's go to the phone lines and see if there's anybody there who'd like to testify in support.
Thank you, Chair. To testify in support of Bill AB 230, please press *9 now to take your place in the queue. We will begin testimony in support with the caller with the last 3 digits of 130. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINE SAUNDERS. I'm the Policy Director with Progressive Leadership Alliance of Nevada in support of Assembly Bill 230. I want to thank this committee for hearing a number of important bills addressing the juvenile justice system this session. We believe that this bill is an important first step as we continue to address systemic racism and build resources for the juvenile justice system to support all youth in the state. Thank you.
Thank you for your testimony, Ms. Saunders. BPS, let's take the next caller in support, please.
Thank you. Would the next caller with the last 3 digits of 151 please slowly state and then spell your name for the record? You will have 2 minutes and may begin.
Thank you. Good morning. My name is Denise Bolaños, DENISEBOLANOS, and I am a member of Return Strong. And today I am reading a statement from a person that is directly impacted that could not be here today. It reads as follows. My name is Shasta, and I have a loved one incarcerated in NDOC, and I also have a child incarcerated in another state. But I believe our story is relevant to what is happening here today and needs to be told. I'm a single mother with 2 wonderful boys, 9 years apart. I have raised my children with compassion, empathy, communication, and consequences for their actions. My oldest son started his first serious relationship at 16 years old, and at first it went well. Within a few months, I started to see red flags, and I tried to inform him that this wasn't a good idea. But he was 16. I wasn't going to forbid him because he would just lash out and want the relationship even more. His father was mostly absent during his life, and at this time he was deployed in Afghanistan. My son's relationship continued to spiral, and he pulled farther and farther away from me and his brother, wrapping himself in the relationship as the girl became more controlling and manipulative. He wasn't sleeping, he wasn't eating, he started skipping school, and I was done with it. And then I came home from work one day, and he attacked me. They found evidence that his girlfriend had convinced him to kill me. She walked him through step by step what to do. They were both arrested and given separate lawyers. Both of them were facing 25 years if tried as adults. She was given a plea deal immediately for 18 months, and her mother was able to be with her every step of the way. After a few weeks, my son was given a plea deal for assault with a sentence of a lot longer. When he's released, he would be a felon for the rest of his life, all before he can buy alcohol or even vote. I was unable to be there for him due to a no contact order. He was given a court-appointed attorney who was incredibly overworked, and I feel she pressured him into a plea deal. I'm not saying my son should not have gone to jail. I just feel he shouldn't have been charged as an adult, and there should have been someone looking out for him. Our brains are not fully developed until we're 25. There are so many chemicals and hormones coursing through our brains for the brain to fully develop, and it's difficult to treat minors the same as adults when they are not functioning with the same tools as adults are. I am both the parent and the victim and understand the plethora of layers of situations like this, but the reality is that children are children, and they do not belong in adult systems that are not prepared to deal with them appropriately, and they certainly do not belong in adult prisons. And at the point we as a society choose adult prisons and systems, we stop choosing justice. Our children need support services and restorative justice. I know there is discussion of amending this bill to not include certain crimes, but I am here to stand in support of AB 230 as it is now. No child under any circumstances should be direct filed into adult systems. Thank you, Assemblyman Miller, for sponsoring this bill. It is bold, it is courageous, and it is the right thing to do. Again, I am in support of AB 230.
Thank you for your testimony, Ms. Bolaños. BPS, let's take the next caller in support, please.
Thank you. Right. We're going to move on to the caller with the last three digits of 419. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Thank you, Chair Yeager. My name is Benjamin Challoner. That's BenjaminChallonor. I am the Policy Director for Faith in Action Nevada. In the interest of time, I'll be brief. We are in support of AB 230. This process is a continued interpretation of the school to prison pipeline, and we are in extreme support of this bill as it's an important step in correcting the juvenile justice system that we are at right now. Thank you so much for your time, and I will submit my full written testimony to the committee.
Thank you for your testimony, Mr. Challoner, and please do submit the rest of your testimony. BPS, let's take the next caller in support, please.
Thank you, Chair. We'll now move on to the caller with the last three digits of 499. Please press *6 to unmute yourself. Say your name and spell your name for the record. You will have 2 minutes and may begin.
Hello, my name is Jody Hocking, JODIHOCKING. I'm the founder of Return Strong. I also am an impacted family member as my spouse is incarcerated in NDOC and he's been directly impacted by what we're talking about today. He entered the juvenile system at 9 years old for crimes that he committed, with his mother that were part of her addiction. Her addiction and poverty led him to begin committing crimes at a very young age, crimes that were deeply rooted in survival and not an inherent evil on his part. But the way the system's currently designed, the underlying issues that were never addressed, by the time he was a teenager, he made some poor decisions, which happens when you have poor choices and no guidance. But that decision led him to juvenile life in California, to Folsom, to NSP, to Ely, to High Desert, to Southern Desert, to Warm Springs, to Ely, back to Southern Desert. And then he came home for 10 months and now is back in prison. This journey tells nothing of who he is as a human being. His crimes are all related to the same issues that are connected to the PTSD and trauma that he endured as a child. Prison's never going to help him do better in a community or in society. Yesterday, I spoke to a young man at Ely State Prison who was incarcerated as a juvenile in Nevada through the certification process. He told me, Jody, I remember the day that they sent me to prison, and I know I'm not supposed to say this, but I was both scared and excited at the same time because I was going to go be with all of the big OGs, and in my life, it was like an honor. But now, 10 years later, I'm scared. I'm getting ready to come home in a few years, but I'm terrified of facing life out there. I don't know how to live like that. I was a baby when I came here and I have nothing to come home to, and NDOC's done nothing to help me to get ready for that. But I also don't want to come back here, and I don't know how to do it. We have to do better by our children. None of them belong in adult courts or systems, and we can stop this now, right here, by changing the law. That doesn't fix everything, but it's a huge step in the right direction. We support AB 230. Thank you.
Thank you for your testimony, Ms. Hawking. BPS, let's take the next caller in support, please.
We are currently taking testimony in support of AB 230. If you have recently joined the call and would like to testify in support, please press *9 now to take your place in the queue. And we will continue with our next caller with the last 3 digits of 771. Please press *6 now and state your name and spell your name for the record. You will have 2 minutes and we begin.
Leslie Turner, Elias, Lieturner. I'm in Assembly District 11, Mass Liberation Project Plan. There should be no time that a youth is sent to adult court. If a youth pulls the trigger and kills someone, that doesn't change the fact that they're still a child. Holding a child accountable is not what we are debating. What is acceptable accountability for a youth that commits a very serious crime? The answer is healing for everyone. Counseling, resources, mentoring, culturally relevant programming, mindset shifting, spiritual growth, exposure to what life could be, investment in their future. These forms of accountability may not seem enough to prosecutors or victims because we've been brainwashed to believe that punishment, retribution, torture, and confinement are our only means of justice. We as a society have conflated the emotional satisfaction of revenge with justice. Justice is getting to the root cause. Justice is building legacies for the future. Justice is healing and restoration. None of which are delivered by putting youth in adult systems. None of which are delivered by the criminal legal system as a whole. Research that goes back to the 90s can be referenced that tells us how we should be handling kids and how we should be handling delinquent behavior. Here are some questions to consider. Is there data that connects more serious crimes or violent crimes to increased levels of maturity or adult mentality? I would argue that if a child takes someone's life to solve a conflict, it is actually indicative of underdeveloped problem-solving skills, poor social interaction skills, and low maturity. Although there's plenty of anecdotal evidence, is there any research specifically on what actually brings a child to take someone's life or join a gang or shoot up a school? Justice requires us to get to the root cause. We can't solve a problem if we don't know why it's happening. And we are not solving the problem by putting youth in the adult system. What is the purpose and goal of placing a youth in the adult system? From my lens, it seems that it's just a way to give youth longer sentences for more heinous acts. If these longer sentences are supposed to serve as a deterrent, have we surveyed youth who it did not deter and asked them what could have helped? Have we talked to them and their families and investigated at length and in depth to truly understand what happened to these kids that brought them to the point of being put into the adult system? How much are we spending annually per youth in the adult system? Can that money be repurposed to service kids in the juvenile system and create infrastructure that is supposedly lacking? Ultimately, we need to keep kids as kids. We need to treat kids as kids. If they do something, we need to hold them accountable in the juvenile justice system. It's not a matter of them not being held accountable. It's a matter of how we are holding them accountable, how we are rehabilitating them, and ultimately how we are
Ms. Turner,
investing
can you please wrap up your testimony?
Yes, that's it.
Okay, thank you so much. We're going to have to leave our supportive testimony there due to time constraints. If there were others on the phone who are not able to testify in support today, I would ask you to please submit your comments in writing. I would also note for the record that there are some exhibits with some additional testimony in support, some folks who we heard from and some who we did not. So I would encourage committee members to look there. At this time, I'll close supportive testimony. I'll go to opposition testimony. I don't believe we have anyone on the Zoom in opposition today. BPS, let's go to the phone lines and see if we have anybody there in opposition to Assembly Bill 230.
provide opposition testimony to Assembly Bill 230, please press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 210. Caller with the last 3 digits of 210, press star 6 to unmute yourself and state your name and spell your name for the record. You will have 2 minutes and may begin.
Michael Wheelahan, MICHAELWHELIHAN. I'm with Clark County DGJS. I'm Assistant Director. I would like to thank the committee members for their time. DGS is opposing the bill due to the fiscal impact on unfunded mandates. This is good policy for our youth. These cases are serious in nature. Youth will need to get proper mental health assessments and counseling prior to the judge making decisions on whether they should be certified or not. Investigations will take longer to complete prior to a judge making the decision. Some youth will not need to be remanded to the adult system and will remain in the juvenile justice system. This will add additional costs for mental health needs and placements. Youth with these charges will be housed separately. They will not be allowed to have roommates due to the serious charges that are pending. We will have to open up additional unit or 2 depending on the language that is agreed upon today. We will need to hire detention staff and medical and mental health staff, get contracts for mental health needs so they are met for the youth. Our population approaches 175 at times. The facility has only 192 beds. DGJS is not budgeted or staffed to meet that capacity. Currently, we are budgeted for 120 youth. We are working with the county management and looking for contract for a unit to provide an emergency placement for the Department of Family and Youth Services for youth that have emergency mental health needs. That could put that program on jeopardy or on hold. There are several other bills that, if passed, will impact detention capacities. Detention capacity will be overcrowded and exceeded and will place youth at risk by having too many youth in the facility. Other programs will have to be closed if there is no funding for this mandate. This will impact programming for current youth and outcomes for the children currently in juvenile probation. Thank you.
Thank you for your testimony, Mr. Wheelahan. BPS, are there additional callers in opposition?
To provide testimony in opposition of Bill 230, press star 9 now to take your place in the queue. Chair, there are no more callers to give testimony in opposition of the bill.
Thank you so much, BPS. I will now close opposition testimony. I will open it up for neutral testimony. I don't think we have anyone in the Zoom with us who is neutral. BPS, let's check the phone lines to see if there's any neutral testimony there.
To provide neutral testimony on Assembly Bill 230, press star 9 now to take your place in the queue. Chair, there are no callers in the queue to provide neutral testimony.
Thank you, BPS. I appreciate that. I will now close neutral testimony. And at this time, I'm going to hand it back to Assemblyman Miller to provide concluding remarks on Assembly Bill 230.
Thank you, Chair Yeager, Assemblyman C.H. Miller, for the record. In closing, I appreciate the remarks of many of those who called in today. I understand that you are supporting the bill with the amendments because you have to, and not because you are in love with the idea of not capturing all youth at this time. I share your feelings and your passion and will work hard to continue moving the goalposts forward. I would also like to acknowledge former Assemblywoman Shay Backus, who worked on this bill in the interim and planned to bring it forward. I was happy when Assemblywoman Selena Torres brought the bill to my attention and I was able to pick it up. I want to thank all of the co-sponsors, many of which are in this actual committee, who have a lot of questions, who have asked great questions, and who care about making sure that our juvenile justice system is just, that our criminal justice system is just, and want to correct the wrongs that previous bad legislation brought forward. I want to let everyone know that Senator Pat Spearman will be amended as a primary sponsor. She was the first senator that agreed to sign on to the bill, but was unable to sign it before I had to turn it in. I'm also open to anyone else that would like to join this bill as we move forward. We are tasked every day with correcting the mistakes of bad legislative decisions of the past, and it's time to correct one that has created generational devastation for communities of color in Nevada. We must pass AB 230 with the amendments for our children's children. Thank you, Chair.
Thank you so much, Assemblyman Miller. I know that was your first bill presentation, and I think you knocked it out of the park. So very, very well done. And, you know, I want to thank you. This issue, as has been referenced, has been brought up over several sessions, and just thank you for your work and talking to folks. I think the broad stakeholders you brought to the table in support of this bill speaks to the hard work that you put into it. And I can tell you as chair, I always appreciate when bills are presented with some level of consensus. It's not always the case, but thank you. And thank you to those who joined the Zoom, worked on this and helped to present, and to those who called in support today as well. So well done. And with that, we will close the hearing on Assembly Bill 230. Members, as you know, we have one final item on our agenda, and that item is public comment. By way of a reminder, we reserve up to 30 minutes for public comment at the end of each meeting. Commenters will have 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. VPS, let's go to the phone lines and see if there's anybody there who'd like to give public comment this morning.
To provide public comment, press *9 to take your place in the queue. We'll begin with our first caller with the last 3 digits of 419. Caller with the last 3 digits of 419. Please state your name and spell your name for the record. You'll have 2 minutes and may begin.
Thank you, Chair Yeager, for the opportunity to speak. Again, my name is Benjamin Challinor. That's BenjaminChallinor, and I am the Policy Director for Faith in Action Nevada. One of the items that has been heard and we hope to be heard is AB 141 and 161. As you know, this coming 31st is the expiration of both the CDC and the governor's eviction moratorium. Last night at his press conference, when asked what is to be done on the eviction moratorium, he says that the state is working with local partners in the judicial branch to determine how to handle that. One thing that the legislative branch can do is pass both AB 141 and 161 to make sure that tenants who are at risk of eviction or who may be evicted due to the COVID-19 crisis will have some support from the state, in addition to the long list of federal aid and unemployment aid. Thank you so much for your time, and I really do hope that the committee takes those 2 measures up. Thank you.
Thank you, Mr. Challinor. BPS, let's take the next caller in public comment.
Thank you. Caller with the last 3 digits of 556. Press *6 now to unmute yourself, and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE. My brother was asphyxiated to death by Reno police in 2015 in Washoe County Sheriff's Office during a mental health crisis. Today I wanted to read a letter on behalf of Candace and Jared Leach, the children of Ronald William Leach Jr., who was killed by Reno police on September 14th, 2006 during a mental health crisis. He was shot in the parking lot of a mental health facility in Reno. Ronnie is the father of 2 children and a grandfather of 6, which 5 of them he never had the chance to meet. He lived life to the fullest, was always adventurous, and loved to travel. He would go without to make sure that others had the things they needed. He had such a big heart and was loved by many. His life being taken from him by another human was just another day on the job and an extra paperwork for some. But to us, he was our daddy, and our lives were shattered and altered on September 14th, 2006, when our daddy was taken from us by unnecessary lethal force resulting in homicide. Time never will heal these kinds of wounds when your loved one is killed by police without consequence. Please support bills that promote transparency and accountability. Thank you.
Thank you for your public comment, Ms. Grant. BPS, are there any additional folks who'd like to give public comment this morning?
Yes, Chair. Would the caller with the last three digits of 681 slowly state and then spell your name for the record? You will have 2 minutes and may begin now.
My name is Darlene Anderson, ANDERSONDARLENE. I'm calling because the requirements under IDEA and what happened during the Individual Disabilities Act when they were passed were to address these issues and provide support. And it amazes me that the local school district does absolutely nothing in providing the preventative services for children who would end up incarcerated. But there is an assessment that takes place prior to the direct violence of children who go to criminal prison institutions. And the data for that must be examined under the scope of the offer of a free and appropriate public education, as involving the justice system just continues to perpetuate the internal slavery and the plantation. And I am sick of it. I can see it's blatant, as they do absolutely nothing to deter children from ending up in juvenile court. And thank you.
Thank you for your public comment, Ms. Anderson. BPS, is there anybody else for public comment?
If you'd like to provide public comment, please press *9 now to take your place in the queue. Chair, the public line is open and working, and there are no more callers in it.
Thank you, BPS. As always, appreciate your hard work in helping us manage all the phone testimony. With that, I'll close public comment. We just may finish this meeting before 11:30 yet. So committee members, anybody else, anybody have anything they'd like to add this morning before we talk about the rest of the week? All right, don't see anything. Thank you again, committee. I know it was a long morning with a couple of bills that were pretty substantial, so appreciate your time and attention. In terms of where we go from here, tomorrow we have 2 bills on the agenda. It will be an 8 o'clock start. We'll be hearing a bill from Assemblywoman Housekeeping and one from our own Assemblyman Orentlicker, who's on the committee with us. And then we do have an agenda out for Monday. It's going to be a 10 a.m. start, and we'll have 1 bill. So that's the good news. Monday, you get a couple extra hours there. I do anticipate we'll have committee meetings the rest of next week. I just don't know what time and how many bills as we continue to have bills come out of drafting and be introduced on the floor. So committee, I hope you have a really great day. I will see you tomorrow morning back in this committee at 8 a.m. This meeting is adjourned.